What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small shock jock in central Minnesota. Apparently, an amateur, a rank amateur shock jock and law firm in central Minnesota. How are you guys today? I am not tardy. It's now 11:01, but it wasn't. It wasn't, though. How are you guys doing today? It's been quite a day. Of course, as you know, the TCPA has been filed for Monica Rial and Ron Toye. Now, what's interesting is that filing does not show up on Research Texas. Which is weird, but it is it? Hold on. It is stamped, filed in Tarrant County. For some reason, it is not on Research Texas. So, very, very odd. But that happened today. What you may not know is that, or maybe you do, but Jamie Markey has also filed her TCPA today. So finally, we've got TCPAs from all of the defendants. This, of course, was expected, and now the fight gets to actually start, which will be great. It'll be great. And and the TCPA for days was definitely a reference to the length of Rial and Toye's TCPA, which is 530 pages if you include the supporting documents. So there we go. I'm gonna eat these Skittles. George Zimmerman, please don't shoot. Someone has asked me in the chat, or asked in the chat generally, when am I going home? It's going to be another week, at least. I'll be bouncing around to some undisclosed locations. Now, to be clear, the TCPA itself, the motion for Rana and Monica is like 27 pages. But they included a whole lot of stuff that's pretty ridiculous. And we'll go through it. Lady Racket stole my haichu, so I can't eat the haichu. But, all right. Before we get into the TCPAs, we're going to take a brief look at Meyer versus Waid. There's been some movement in the case, sort of. There's some motion practice. We're waiting for rulings on it. We're gonna check that out and see what's up with Meyer versus Waid. If you're new to this channel and you're following the Vic Mignogna lawsuit, you should really check out the Meyer versus Waid lawsuit. There's some similar issues here. It is in Texas. It is a very different case, a very, very different case. But it is in Texas. It does involve defamation. It does involve tortious interference with an existing contract. And, I say it's in Texas. It's under Texas law, and it is in U.S. federal court in the Western District of Texas. And that makes things a little bit interesting because he's suing a party from California. So the TCPA in that case will be coming sometime in the next, month or two. They had an even longer start than Vic's case here because of the jurisdictional argument. I have to address a super chat that I missed from the 18th. So yesterday. The reason I missed it was because it was sent at like 3:40 p.m. and I didn't get the notification from Streamlabs. But it was, from Michael Rule, says, aside from buying Ty a Jack Daniels, give Carrie Christie also a drink. The answers Monica gave were very interesting. And for an actress, I've seen better acts and heard better lies. Keep up the good work. And greetings from the Netherlands. Hey, Michael, back at you, buddy. Greetings back to you from the U.S. And I appreciate it very much. All right, so let's get started. Because we've got a lot of documentation to cover. We'll get started on this. We'll burn through it. I don't want to go line by line through these arguments in Meyer versus Waid, although I might end up doing it because it's hard not to, but they're not very long filings. So there are 3 documents. We're going to burn through them pretty quickly, though. So bear with me, and then we're going to get into the Vic stuff. Once we get through the Meyer versus Waid stuff, I'll do the GoFundMe update. At some point, I'll do a quick ad read or whatever, even though they don't give me anything to read. For the Ridge wallet that I was going to do yesterday, I'll do that. As in a little bit as things kind of pick up. So first things first, let's get into this. So this is Meyer versus Waid. So this is Richard Meyer, otherwise known as your boy Zach or Diversity in Comics. This is his response to Mark Waid's objections to the report and recommendations of the United States Magistrate. So we know what he's going to say. They're wrong on everything they said. And Waid has the exact same thing. Waid has one as well. And then Waid also has opposed Meyer updating his or amending his original petition. So let's go through this. Introduction. Defendant's objection should be overruled. Report and recommendation of the U.S. Magistrate Judge correctly concluded that this court has jurisdiction over Mark Waid as a result of Waid calling Texas publisher and convincing that publisher to breach its contract with Richard Meyer, who is also a Texas citizen. Waid's claimed ignorance of the publisher's whereabouts is belied by his multiple affirmations immediately following his interference that he knew the publisher. From the moment Waid deliberately reached out to that publisher, Waid should have reasonably anticipated being hailed into a Texas court to answer for those actions. This court should adopt the R&R factual findings and legal conclusions with regard to Meyer's tortious interference with contract claim. So here's the authorities. Report and recommendation. That's the recommendation and report. Legal standard, purposeful actions directed at the forum. Single phone call will suffice. The R&R was correct. Waid's single phone call is sufficient to invoke this court's jurisdiction. Fifth Circuit has long held that minimum contact with a forum state can be established through a single phone call. See Brown versus Flowers Industries. Holding defamatory statements made during single telephone call was sufficient to support personal jurisdiction. And then here's the footnote. Fifth Circuit has repeatedly cited Brown versus Flowers Industries for this proposition. There's a whole bunch. Let's see. Oh, they just have summaries of each case. I'm not going to go through all of them. The most important line is right there, and then there's a bunch of citations. You guys can actually check them out if you want to screen cap that. So, but let's move through it. In fact, the Fifth Circuit recently upheld jurisdiction based on a single phone call that included Texas citizens, even though the call was not even initiated by the defendant. See Trois versus Appletree Auction Center. There, the defendant participated in a conference call initiated by a third party during which the plaintiff asserted one of the defendants made fraudulent statements concerning his auction company. In rejecting the defendant's claim that a single phone call was insufficient to confer jurisdiction, the court said, although Schnate, the defendant, did not initiate the conference call to TRA in Texas, Schnate was not a passive participant on the call. Instead, he was the key negotiating party who made representations regarding his business in a call to Texas. It is that intentional conduct on the part of Schnate that led to this litigation. Defendant should have reasonably anticipated being hailed into Texas court as a result of reaching out to Texas via telephone in order to garner business and make specific representations. This court has likewise found jurisdiction where the content of the non-resident's communication with Texas formed the basis of the plaintiff's cause of action. See Office VP LLC versus Ideal Healthcare. When the actual content of communications with the forum gives rise to intentional tort cause of action, this alone constitutes personal availment. So, again, this is a very basic argument that is being made very complicated. If you do some intentional thing to someone in a state, then you've done it in that state, and that state has jurisdiction, whether you knew the act would take place, like whether you knew they were in, how do I word this? You know they're somewhere, okay? So whether or not you know that they're in this specific state doesn't matter so much. Again, imagine pointing your gun at someone and they're across state lines and you shoot them, intentionally shooting them. The civil action would be held in the place where they were shot. That's where the damage was done. That's where they were. That's where the intentional tort took place. It doesn't matter that you didn't realize you were in that state. If you could just get out by, no one would know what state they were in ever. So it's a very weird sort of argument, but they're trying. Thus, personal jurisdiction for intentional torts is established when the cause of action arises from the defendant's communication with a citizen of the foreign state. Again, Waid's continued reliance on Calder v. Jones and related cases is unavailing. The Fifth Circuit has made clear in Trois versus Appletree Auction Center and elsewhere that the correct analysis is to determine whether the defendant's conduct connects it to the forum in a meaningful way, quoting Sangha versus Navigate Ship Management Private Ltd. All right. Waid's intentional acts directed toward Texas give rise to Meyer's tortious interference with contract claim. Waid intentionally directed his actions toward Texas to interfere with a contract that was between Texas citizen and performable in Texas, as the evidence submitted with a response to defendant's motion to dismiss for lack of personal jurisdiction showed. Antarctic Press and Meyer, both citizens of Texas, entered a contract to publish Jawbreakers that was performable in Texas. It is undisputed that Waid intentionally reached out to AP by calling AP's landline business phone to discourage AB from publishing Jawbreakers, and Waid bragged on social media that he had done so. Despite Waid's initial denial under oath to this court that he did not know where AP was located until the suit was filed, and faced with his recorded comments in Houston 10 days after the call, he now admits, as he must, that he knew AP was Texas-based at least by then. Waid's claim that he only learned of AP's location after the call is completely implausible and not credible. He is completely unable to explain how he became aware of that fact. Waid also professed on at least 2 occasions within the same 2-week period, one of which was 2 days after the call, that he had previously met and knew AP's owner and knew that he was a, quote, good guy. Waid denies using the internet to identify the 210 area code number he dialed for AP's landline, probably because AP's San Antonio address is prominently displayed on its website. He claims instead to have procured the number from some unidentified industry source. Waid's assertion that he did not know where he was calling when he reached out to AP is simply not credible. Waid's actions during that call were intentional and deliberate. He wanted AP to drop Jawbreakers, and Waid succeeded. The case falls directly in line with Trois versus Appletree Auction Center discussed above. Like the defendant in that case, Waid intentionally reached out to a Texas citizen to interfere with a contract to publish Jawbreakers. When Dunn spoke to Waid, Waid was an active participant advocating against publication of Meyer's book, just as a defendant in Trois versus Appletree Auction Center was an active participant making misrepresentations. Here, Waid was a party in 2 telephone calls with Texas participants, one with AP's office manager and later with AP's owner, with the intention of convincing AP to breach its contract with Meyer. Waid's actions during those calls alone are sufficient contacts with Texas for this court to assert personal jurisdiction over him. Going on, even if Waid were being truthful regarding his alleged ignorance of AP's Texas citizenship, despite the evidence to the contrary, that is not enough to defeat jurisdiction. Evidence to the contrary, footnote 4. Because Waid's knowledge of AP's Texas connections is disputed, and there is conflicting evidence of his knowledge in the record, the court must resolve that dispute in Meyer's favor. That's true. That's because jurisdictional challenges are resolved typically in favor of the plaintiff, or are to be resolved liberally in favor of the plaintiff, and with an intent of finding jurisdiction. Again, the key inquiry is whether Waid's intentional actions toward Texas give rise to the cause of action. It is undisputed that Waid called AP's business telephone with a San Antonio area code. Federal courts are critical of arguments that willful ignorance of the state to which the defendant direct a communication defeats jurisdiction. See Strange versus Carnival Corp. citing cases and approving of court's rejections of the argument that a defendant's ignorance of the location of the phone the defendant had called defeated jurisdiction. Luna v. Shack, holding that sending unsolicited text messages to forum state subject the defendant to personal jurisdiction in the state regardless of the defendant's knowledge of the recipient's phone location. Schneider versus Hardesty. The only possible explanation for defendant's ignorance of the plaintiff's geographic location is that he intentionally buried his head in the sand, and that cannot save him from being subject to jurisdiction. In this case, Waid intentionally reached out to a San Antonio business with a San Antonio area code for the purpose of infringing with that business's contract, solicited a call back from the company's owner, and executed on his intention to interfere with the contract. Finally, there is no question that Waid's bullying influenced AP's owner to cancel publication of Jawbreakers. As described in the MTD response done, AP's owner lamented to his colleague just before his call will with Waid that AP was caught in the middle and was being bullied into not publishing Meyer's book, but that he was still proceeding with the publication. Motion to dismiss response at paragraph 7. When Dunn called Waid 10 minutes later, they spoke at length, immediately after which AP announced its decision to drop the project. Obviously concerned about exposure, Waid sought to insulate himself from the consequences of his actions by repeatedly soliciting an admission from Dunn that Waid had not bullied him, which Dunn refused to provide. That is not how innocent people act. It is clear that the telephone conversation between Waid and Dunn was a tipping point for AP, and Waid knew it. Conclusion and prayer. Report and recommendations correctly found Waid's intentional actions directed towards Antarctic Press and Richard Meyer give rise to Meyer's tortious interference claim. Waid should not be allowed to tortiously interfere with Texas contracts and then claim he could not reasonably expect to be hailed into a Texas court. Court clearly has jurisdiction. Waid's objection must be overruled. Okay. So the way this works is they're only responding in this case to Mark Waid's objection to the report. So they don't, in this part, have to argue on the defamation claim that was dismissed for lack of jurisdiction. They've done that in their own objection. This is merely the response to Mark Waid's objections. Okay, so Mark Waid's objection was that they love that the defamation claim was dismissed for lack of jurisdiction. They objected to the finding that the tortious interference claim was allowed to go forward. So this is the response to that. Now, they addressed the defamation claim in their own objection, and we have right here the response from Waid to that objection. So we'll burn through this one real quick too. Again, going to be the same type of thing very quickly, but it's going to argue the exact opposite, probably using the same stuff. Plaintiff Richard Meyer's objection to magistrate judge's report and recommendation should be overruled. Very familiar first line. Magistrate Judge Lane correctly concluded that no personal jurisdiction existed as to plaintiff's defamation count. Plaintiff's sole argument is that Judge Lane misread the complaint's allegations. The argument is meritless. Ooh. Plaintiff's complaint expressly based any defamation claims on social media statements. As Magistrate Lane correctly observed, plaintiff's complaint unequivocally based any defamation claims on defendant's Mark Waid's alleged statements made through his various social media accounts, and plaintiff did not and could not raise any grounds for personal jurisdiction as any defamation claim based on any such social media statements. Meyer seems to argue with Waid that personal jurisdiction cannot be based solely on statements being accessible on social media or the internet in the forum state. Plaintiff refers to the complaint's vague allegations regarding defendants having allegedly described his discussions with Antarctic Press in interviews and on comic convention panels. But none of these allegations mention Texas. They don't have to. Moreover, it bears repeating that plaintiff expressly based his defamation count on alleged statements made through defendant's various social media accounts. It makes sense that plaintiff would not have based any defamation claim on defendant's Houston statements because those statements occurred after Antarctic Press decided not to publish plaintiff's book. This is a damages argument, not a jurisdictional argument, and it should fail here. It is only after AP's deposition testimony demolished plaintiff's tortious interference claim and after Judge Lane's R&R that he now seeks to desperately expand his defamation claim. That's an interesting claim. Very interesting claim. Plaintiff expressly chose to base his defamation count on social media statements, and Judge Lane correctly found that no personal jurisdiction existed as to that claim. Citing Revel versus Lidov and Fester versus Wolf. Plaintiff should not be permitted to amend his complaint. Now, this should actually be here in the response for motion for leave to file amended complaint, but they included an argument here as well. So, plaintiff's only notice this is actually very thin on case law, right? The only one they have Revel versus Lidov and Fester versus Wolf tacked in there. They don't have any citing authority in here, in this area. They didn't do that. They may have thought they didn't need it. My guess is they can't actually support those statements. Okay, plaintiff's only other argument is that he has filed a motion for leave to amend to expressly refer to defendant's Houston statements. Plaintiff does not raise arguments in his objection for why he should be permitted to amend, but rather only references his motion for leave to amend. Defendant therefore refers the court to his response to plaintiff's motion for leave, which sets out several independent reasons for why plaintiff's request to amend should be denied. Defendant will not repeat all the arguments in his motion, in his response to the motion for leave, which he incorporates herein, but he summarizes those arguments for convenience here. Plaintiff's proposed amended complaint still seeks to replead claims based on defendant's prior statements, over which there's undisputedly no personal jurisdiction. He merely seeks to add a new claim based on defendant's statements in Houston that are allegedly similar to his prior statements, but the defamation count would still be inextricably intertwined with alleged statements regarding which no personal jurisdiction exists. Yeah, but he republished those statements in Texas. Plaintiff cannot establish personal jurisdiction for any new claim based on the Houston statements. Thus, even if plaintiff's original complaint were to be read as to base a defamation claim on the Houston statements, or even if plaintiff were permitted to amend, there would still not be personal jurisdiction. Knowledge of the particular form in which a potential plaintiff will bear the brunt of harm forms an essential part of the Calder-specific jurisdiction test. They're literally arguing right now that Waid didn't know he was in Houston? Is that what's going on here? Foregoing requirement is based on Calder v. Jones, a case in which defamatory statements were widely published in the forum and in which the defendant knew the plaintiff resided in the forum. Plaintiff cites no authority allowing personal jurisdiction based simply on the fact that alleged defamatory statements occurred in the forum where the defendant did not know the plaintiff resided in the forum and would suffer the brunt of harm there. Is absolute nonsense. That one is absolute nonsense again. The funny thing is, no, never mind. Of course, the statements, he's going to bear the brunt of harm for statements made in a location if he was defamed in Texas. Now, if the opposite were true, if Meyer lived somewhere else and tried to bring this claim of statements made in Texas to a different forum, Waid would argue that they properly belonged in Texas because that's where they're made. And that's where this argument gets very, very disingenuous very, very quickly. In discussing the defamation account, the R&R cited Calder and Clemens versus McNamee. As in Calder, the defendants and Clemens undisputedly knew that the plaintiffs resided in Texas. Defendants' lack of knowledge of plaintiff's forum location itself defeats jurisdiction, but in addition, the alleged defamation otherwise lacks the requisite substantial connection to Texas. As it did not discuss this is the worst argument. As it did not discuss Texas, relates to a book unrelated to Texas to be created by a team spread across several states and relates to plaintiffs' anti-diversity views, which have no relationship specifically to Texas. They don't need to. This is the weirdest part of their argument, and they think it's very, very clever, but it's not. There's no requirement that for defamatory statements that the book that Meyer is writing would have anything to do with Texas. The defamatory statements are made in Texas to an audience in Texas. It's not like he made them and broadcasted them only to France or something like that. They were made to a live Texas audience. That's where the damage is being done. Separately, plaintiff's proposed defamation claim based on the Houston statements would be plainly futile because it fails as a matter of law for obvious reasons. The claim would be time barred under Texas law because the Houston statements occurred beyond the 1-year limitations period, nor would the amendment relate back to the original complaint. How could they be time barred beyond the 1-year limitation period if they were made after the non-time barred other defamation statements? That doesn't make any sense. Aside from the obvious limitations bar, plaintiff's defamation count also fails as a matter of law for failure to comply with the Texas Defamation Mitigation Act, which requires a timely demand for correction or retraction, and which plaintiff does not and could not plead. That might be the fatal argument here. It doesn't really belong in the jurisdictional argument. But I don't know that they complied with the TDMA. I just don't know if they did or not. On top of all this, plaintiff unduly delayed in seeking an amendment until after Judge Lane issued his R&R. Finally, as further discussed in defendant's objections to the R&R, defendant submits that personal jurisdiction likewise does not exist as to plaintiff's tortious interference claim. Dismissal of the interference claim, which defendant believes Fifth Circuit precedent requires, would further weigh sharply against retaining a defamation claim that could only possibly be based on the alleged Houston statements. Thus, for many separate reasons, plaintiff's request for leave to amend his complaint should be denied. Even if the court were to allow amendment, the court should still overrule plaintiff's objection to the R&R. So there you go. There's some stuff in here that has nothing to do with jurisdictional arguments. They're trying to make substantive arguments about other aspects of the procedure, which they have not objected to at this point. So they may have forfeited their ability to object to the lack of TDMA letter, though. That'll be interesting. But that issue isn't before the court, and that's very important. All right, so here is we're cruising through this, so that's nice. That's good. We'll get through this one. This one is 25 pages, but I think there's some exhibits that we don't need to go through. 12 pages. So we'll get through this real quick. This is the defendant's response to motion for leave to file plaintiff's first amended complaint. So Meyer makes his motion to amend his complaint to clarify that it includes statements made specifically in Houston, Texas. So here we go. And then after this, I'll hit super chats and then we'll go straight into the TCPA. Plaintiff Richard Meyer's motion for leave to file a first amended complaint should be denied for multiple independent reasons. First, the proposed amendment still asserts a defamation count that does not fix the personal jurisdiction problems. I disagree with that. I disagree that there are personal jurisdiction problems there in general. But second, the amendment would be plainly futile as a matter of law because it would not survive a statute of limitations defense. That's weird because they didn't argue a statute of limitations defense on the other one yet. Now, they haven't filed a motion to dismiss yet, but that should come later. Statute of limitations should come in argument in their motion to dismiss, not on jurisdictional grounds, but on other grounds. And separately, plaintiff did not comply with the requirements of the Defamation Mitigation Act, which again, that should be in a different motion than this one. On top of these reasons, plaintiff's request to, well, maybe, we'll see. Plaintiff's request to amend suffers from undue delay. Does it? That delay was caused by you. Finally, as set out in his objections to the magistrate's R&R, plaintiff's tortious interference claim should also be dismissed for lack of jurisdiction. Therefore, keeping any defamation claims in Texas would be especially inefficient. Yeah, well, that's if we win. Procedural background. Plaintiff originally filed this lawsuit on September 19th, 2018. Nowhere did he mention Texas in the original complaint, and he expressly based his defamation counts on statements allegedly made through defendant's various social media accounts. That's not true, because it incorporates prior paragraphs into that claim, and the prior paragraphs, they mention social media accounts and conventions and appearances. Defendant Mark Waid filed his motion to dismiss for lack of personal jurisdiction on November 2nd, 2018. In that motion, defendant argued that no personal jurisdiction exists as to plaintiff's defamation claim, among other reasons. This is based on alleged defamatory statements made through the social media accounts. In response, plaintiff argued that defendant had also repeated previous statements while at a convention in Houston, but effectively conceded that no jurisdiction could exist as to the initial or original statements. Notably, in his response to the motion to dismiss, plaintiff made the point that at its base, this is a tortious interference case. Plaintiff's alleged interference claim is based on the allegations that a publisher, Antarctic Press, decided not to publish his book after a phone call between defendant and AP. The newly alleged statements by defendant in Houston occurred after AP had made the decision not to publish the book. Specifically, the statements in Houston occurred in May 2018, more than 1 year ago. But it wasn't more than 1 year ago when the action was filed, and they're claiming that those statements are incorporated into the body of the text. So this is not, the statute of limitations argument is very, very weird to me. In his reply, defendant reiterated that the basis of plaintiff's defamation claim was social media statements over which jurisdiction undisputedly did not exist. On June 10th, 2019, Magistrate Judge Lane issued his report and recommendations, correctly finding defamation count was based on statements for which there is no personal jurisdiction. Plaintiff filed his motion for leave to amend and seeks for the first time to partially base his defamation count on the Houston statements. Argument. Rule 15 gives the court extensive discretion to decide whether to grant leave to amend after the time for amendment as of course has passed. Courts may consider such factors as undue delay, undue prejudice, and futility of the amendment. A proposed amendment should be denied if the proposed claim fails to state a valid claim or if the plaintiff fails to show personal jurisdiction would exist. But these two are both defeated by the proposed claim. The proposed claim would be valid, and it would show that personal jurisdiction would exist. More generally, Rule 15a maintains the necessary power of a district court to manage a case. That's, and again, that one might be fatal to this argument because the district court might just want to hear both of them. Plaintiff's proposed defamation count still does not support personal jurisdiction. Plaintiff's proposed amendment seeks to replead claims over which there undisputedly is no personal jurisdiction. While plaintiff seeks to clarify the defamation count is also based on defendant's statements in Houston, the proposed amendment is still premised on alleged statements over which there undisputedly is no personal jurisdiction. Proposed amendment to the defamation count states, including his statements described above in Houston, Texas, Waid has intentionally published statements of fact to his followers and the general public regarding Meyer, including falsely stating that Meyer published the first and last names of comic book store employees to encourage his followers to harass and threaten them, as well as characterizing him as racist, a serial harasser of minorities, and as affiliated with white supremacists. Let's pause for just a second here. Yes. Including these statements, Waid has intentionally published statements of fact to his followers and the general public regarding Meyer. That is true, including the statements in Texas. Now, how do I word this? These acts took place in Texas. They did. And he made these statements in Texas. There's nothing, again, you might try and make a damages claim or try to exclude statement. So what you would do is you would argue that the statements that were made outside of Texas caused the damage and are not subject to jurisdiction. I don't think that would be a very effective argument, personally, because the question is, does Texas have jurisdiction over the claim? Now, in Texas and in federal court, you have to provide sufficient notice to the party to know what they're being sued for. This claim provides enough notice to the party. They know that he should be expected to be hailed into court for his statements in Houston, Texas. This is including those statements. So this isn't the defeating claim that they're arguing. At least I don't think so. The judge may disagree, but this amendment, just adding the including in Texas part. Remember, the allegations about the Texas statements were already there. It didn't specifically name Texas, but that doesn't matter because they need to be expected to be hailed into court for their statements to the followers and the general public. And if you want to argue that there's no jurisdiction over some of those statements, fine, but you still have a reasonable expectation to be hailed into court in Texas for statements made in Texas. So there we go. That's my thoughts on it. I don't know how the judge will rule. The above reference to followers is a reference to defendant's social media accounts. As in the original complaint, plaintiff alleges that defendant has thousands of friends following his Facebook posts and almost 100,000 Twitter followers. Proposed amendment further alleges that at various times Waid has described Meyer as a serial harasser of women and minorities and claimed that he promotes hate and intolerance, which he did in Texas on the hate and intolerance part. In the proposed amendment, plaintiff introduced a new heading entitled Mark Waid's Continued Defamation of Richard Meyer, and then alleges that defendant made certain statements in Houston at a public comic book convention. Plaintiff concludes his allegations of the Houston statements with the following: by making such statements in Houston, Texas, and elsewhere, Waid defamed Meyer and caused him damage. That's true. That's true. They're arguing again. They're trying to make fact arguments in their in this jurisdictional argument claim. This isn't the time for it. Right now, they have to say that there's not good cause to amend, and they're trying to say that these will fail as a matter of law, not as a matter of law, that these will fail, but these are fact questions. Which statements cause the damage? That's not a matter of law. That's a matter of fact. Thus, plaintiff's defamation count remains based solely on the previously alleged non-Texas statements. Alleged defamatory statements made at different times and for different audiences represents completely different torts because they are different publications. In assessing personal jurisdiction, therefore, a district court must consider whether personal jurisdiction exists as to each alleged defamatory statement. A plaintiff bringing multiple claims that arise out of different forum contacts of the defendant must establish specific jurisdiction for each claim. Thus, even if a claim based on the Houston statements could survive a jurisdictional challenge, which is noted below, defendant does not concede, plaintiff's proposed amendment seeks to also maintain defamation claims for which there is undisputedly no personal jurisdiction. For that reason alone, the proposed amendment should not be permitted. In fact, in his motion for leave to amend, plaintiff does not identify how amendment would confer personal jurisdiction with regard to the amended defamation count. In addition, even if merely adding the Houston statements while also keeping other non-Texas statements would be proper, the proposed amendment presents substantial practical problems. Allowing litigation of the proposed defamation count to proceed in Texas would require the court and any jury to parse the defamation allegations to ensure that any causation and any damages are only tied only to the Houston statements. That's a fact question. That's a fact question. That's what the court's job is. So that's not very helpful. Defendant emphasizes that plaintiff's defamation claims, both previously alleged and proposed, are entirely meritless for many independent reasons, but these issues should not at the outset even be decided in Texas. Exacerbating the complications, plaintiff has alleged that the Houston statements are similar to the prior alleged statements. Plaintiff's proposed defamation claim based on the Houston statements, therefore, is necessarily intertwined with alleged statements that cannot, as a matter of constitutional law, be litigated in Texas. The court need not permit the unnecessary complications this would present. Notably, the Houston statements occurred after AP had already decided not to publish plaintiff's book, which is the actual gist of plaintiff's lawsuit. Plaintiff should not be permitted to try to use these Houston statements to bootstrap into the case prior alleged statements over which there is clearly no jurisdiction. A case relied upon by plaintiff highlights the fact that the court should not allow amendment. In Martin's Herond Imports, Inc. versus Diamond and Gem Trading, the plaintiffs proposed an amended claim under the guise of clarifying the scope of the claim that was merely attempting to argue the same theory that failed under an earlier pleading. Same can be said of plaintiff's proposed amendment, which effectively seeks to pursue a defamation count that rests on a basis for which there is no personal jurisdiction. Rule 15a preserves the court's discretion to manage a case, and it should use that discretion to refuse to allow amendment under these circumstances. As indicated above, plaintiff's proposed amendment presents substantial jurisdictional issues. The court need not ultimately decide whether a defamation count based only on the alleged Houston statements would support jurisdiction, because plaintiff's proposed count is also expressly based on alleged conduct that plainly does not support jurisdiction. The difficulties presented by plaintiff's proposed amendment are enough to deny that amendment. Even a claim based solely on Houston statements presents jurisdictional problems. In any event, there is no personal jurisdiction over a defamation claim based on the Houston statements. They're going to do this Calder test again. This is not a good argument. Merely because a defamatory statement is published in the forum state does not necessarily support jurisdiction. Instead, knowledge of the particular forum in which a potential plaintiff will bear the brunt of harm forms an essential part of the Calder specific jurisdiction test. Revel versus Lidov. Foregoing requirement is based on Calder v. Jones, a case in which defamatory statements were widely published in the forum and in which the defendant knew the plaintiff resided in the forum, as explained by the Fifth Circuit. In Calder, the Supreme Court held that when an alleged tortfeasor's intentional actions are expressly aimed at the forum state, and the tortfeasor knows that the brunt of the injury will be felt by a particular resident in the forum, the tortfeasor must reasonably anticipate being hailed into the court there to answer for its tortious actions. They're really focusing on this line as if this line not existing precludes the other part from existing, which is here. And they're focusing a lot on knows as in not being ignorant rather than knows that the injury will be felt, again, by a resident in the forum is... First of all, he was a resident in the forum, so they're focusing on knowing that he's in the forum, a resident in the forum, and I just didn't know. That's not what matters so much. Statements made in Texas to a Texas audience are likely to cause damage in Texas. In this case, defendant undisputedly did not know plaintiff resided in Texas. In fact, plaintiff publicly held himself out as being in New York. Again, Twitter locations, I don't think count, but maybe. Accordingly, Fifth Circuit precedent requires a finding that plaintiff's proposed claim based on defendant's Houston statements would still fail for lack of jurisdiction. Defendant's lack of knowledge of plaintiff's forum location itself defeats jurisdiction, but in addition, the alleged... So guys, just so you know, if you don't know that someone lives in a forum state, you can apparently just murder them in the forum state and not be sued there. You didn't know they lived there, right? That's fine. Even if a jurisdiction were appropriate for a claim based on the Houston statements, this is one of those cases which is fair and reasonable factors weigh against exercising jurisdiction. Defendant has no connection to Texas. Not true. He just mentioned doing a business appearance in Texas, so he has some connection. Texas has little interest in resolving the proposed defamation claim. Keeping only part of plaintiff's defamation count in Texas would undercut the efficient administration of justice, and other states, aside from Texas, at least California, have shared interests in this dispute. The alleged defamation concerns plaintiffs... I don't think so. He wasn't damaged in California, so that's a hard argument to make. The alleged defamation concerns plaintiffs' anti-diversity views about the comic book market generally, which is not centered in Texas. But his contract was there, and he's there, and he does business there. Relates to a book whose subject matter has no relationship to Texas, which is being created by a team spread across multiple states, and the subject matter of the alleged defamatory statements do not discuss Texas. Moreover, as noted above, plaintiff alleges that Houston statements were like earlier statements aimed at the general public regarding which there undisputedly is no personal jurisdiction, such that splitting up plaintiff's defamation theory makes no practical sense. In addition, by plaintiff's own admission, the real gist of the lawsuit is the decision not to publish the plaintiff's book, not the Houston statements. Plaintiff's interest in securing relief as to this claim is extremely weak. Plaintiff alleges the Houston statements are substantially similar to earlier statements without connection to Texas, and the Houston statements occurred after AP decided not to publish the book. Plaintiff's proposed amendment is also futile for obvious merit-based reasons. If a proposed amended claim fails to state a claim upon which relief can be granted, the amendment is deemed futile and the district court should not allow it. Plaintiff's proposed defamation claim is time-barred. Each distinct publication of a defamatory statement inflicts an independent injury from which defamation cause of action may arise. Accordingly, separate alleged defamatory statements represent separate and independent defamation claims, each with its own accrual date for limitation purposes. In Texas, a defamation claim is subject to a 1-year limitations period that accrues upon publication of the statement. Fifth Circuit has granted dismissal when a Rule 12b6 analysis shows the claim is time-barred. Here, the alleged Houston Convention statements occurred in May 2018. Plaintiff seeks to state a claim based on those statements more than 1 year later. No, he doesn't. He's clarifying that those statements are included in the original one. Whether or not that argument works or not, I think this is a poor argument. Accordingly, any claim based on the Houston statements would be time-barred as a matter of law, nor could the amendment relate back to the original complaint. Texas law treats each alleged defamatory publication as a single transaction with an independent injury. A proposed defamation claim based on a distinct publication does not relate back to the original complaint, even where all the statements concern the same subject matter. So what they're trying to argue here, I know this is really boring. What they're trying to argue here is that in his amending of the complaint, that he's adding these statements to it. What Meyer is trying to argue is that he already had included those statements in his original complaint and that they're clarifying that these statements are already there. So this depends on how the judge decides that works. If they had sufficiently included the statements and merely needed clarifying language to clean it up, fine. If they're including new statements in an original cause of action, that's a new claim. I don't think Meyer would argue that this is a new claim, especially because they're amending. I mean, they're literally amending the same cause of action to just clarify that it includes Texas statements. All right. Plaintiff's defamation claims fail to satisfy Texas Defamation Mitigation Act. This may be a good argument. I don't know, because they had a 60-day window to object to TDMA letters, but I don't know if they had a 60-day window to object to the non-sending. So here, let's read this real quick. We're almost done. To make out a successful defamation claim in Texas, a plaintiff must comply with the requirements of the Defamation Mitigation Act, Tubbs versus Nickel. Under the Defamation Mitigation Act, a person may maintain an action for defamation only if that person has made a timely and sufficient request for correction, clarification, or retraction from the defendant. Such a request must be made within 1 year of the relevant statement's publication. Fifth Circuit has held that failure to timely make the required demand requires dismissal of the defamation claim. Because plaintiff failed to follow the requirements of the DMA, her defamation claim fails as a matter of law. Plaintiff has not pled and cannot plead he satisfied the demand requirements of the DMA, thus amendment should be denied for this separate reason. This may, like I said, this may actually be a defeating claim. I don't know that they sent out that letter or that they sent any request for correction or retraction. I don't know. I don't know. Plaintiff's proposed amendment was unduly delayed. Plaintiff is correct that this case is at relatively early stages, but plaintiff's delay is still appropriately considered. In exercising its discretion to deny leave to amend a complaint, a trial court must properly consider an unexplained delay following an original complaint and whether the facts underlying the amended complaint were known to the party when the original complaint was filed. Combined with all other circumstances, plaintiff's delay, this is a toss-up argument. They're not serious here. Plaintiff's delay should further tip the scales against amendment. That's why they're saying it should tip the scales against amendment. If it were sufficient, they would say that it's good enough on its own. As discussed above, the core of plaintiff's lawsuit is AP's decision to not publish the book. Plaintiff's proposed amended defamation claim remains intertwined with alleged defamatory statements over which there is undisputedly no jurisdiction. Plaintiff also waited until after Judge Lane's R&R to seek amendment. In addition, that's to remedy part of the problem with the recommendation. In addition, it is only after AP's deposition testimony demolished plaintiff's tortious interference claim that plaintiff now seeks to base a claim on defendant's alleged defamatory statements occurring after AP's decision. That's not true. Those statements were already included in the original complaint. In no way are defendant's Houston statements a genuine part of plaintiff's actual complaints which concern AP's decision not to publish his book. Again, that's a throwaway argument. No personal jurisdictions for the TI claim. This is weird. So they're just throwing this in there. As discussed in defendant's objections to the R&R, defendant submits that plaintiff also has clearly failed to establish personal jurisdiction as to his tortious interference claim. Dismissal of the TI claim would further weigh strongly against maintaining Texas a single defamation claim based on Houston statements. None of this lawsuit should be litigated in Texas, but even if the court were to uphold the R&R's findings as to the TI claim, plaintiff's motion for leave to amend should still be denied for all of the reasons discussed herein. All right, so that's that. I'm not going to go through the exhibits. They don't really matter. The best argument in here is the TDMA claim, just because I don't know. Now, maybe they did. Maybe they did do a TDMA claim and or do a TDMA takedown request. I have no idea. But if they didn't, that could be a huge problem for them. So that's that, guys. the update in Meyer versus Waid. Oh, Meyer has asked until July 23rd to file his response to this opposition. So he will get that, and that was granted by the judge. So July 23rd, he will have a response. That's what, Tuesday? Something like that? Let's see. Yeah, Tuesday. He will be filing his response to this document. So we'll try and keep up on that one. This is in a really, that case has been really quiet and normal and boring. So, but we'll see how it goes. Either way, it looks like the TI case is going to survive. And despite their posturing, I don't think the TI case is dead on arrival in any sort of way. Certainly not from the deposition testimony, which said that up until Waid's call, they were still publishing the book. So we'll move over here in just a second. Let's get this GoFundMe. Hold up. Do I have a... Let me get... The GoFundMe for Vic is doing fantastic. Holy cats. The little hiccup of the names being removed has clearly been overcome by y'all's generosity. Thank you so much. We've got $230,100. We're over 7,000 supporters. That is amazing. That is amazing. Thank you so much. And a huge shout out to Sebastian Soul with $1,000 contributed 28 minutes ago. That's awesome. That's awesome. Pushing us over that 230,000 mark. So that's great. We'll see how we go. We've got lots of people. Thank you again for not posting with funny names anymore. The Fun Police came out. And said no more encouraging funny names. So I have to discourage all funny names. But again, as I told GoFundMe, if there are any potentially offending names, know that those we will treat as a false flag attempt to violate the campaign rules. And Vic's legal team, me, none of us have anything to do with any of that. Again, I can't put a funny name up because I will not contribute to this campaign personally, as it might violate the terms of service. Same thing with Ty. So that obviously is not happening. And I would assume same with Vic. I don't think Vic is in the business of donating to his own campaign. That would be very, very weird. So we are not responsible for any of the names that come in. We've clearly communicated that to GoFundMe, but that's how that goes. So again, thank you for your generous contributions to that. Okay, let's do the super chats real quick. We've got Elliot Joubert says, my Great Danes on laxatives could not make as much dog poop that's present in this anti-slap. Yeah, I'm anxious to read through it in a sitting. I've only been getting clips of it all day. It'll be great. It'll be great to explore this document with you, and I'll give you my thoughts as we go. Inquisitor Jack says, got an ad from for the Brian Banks film coming out in August on the Shield Hero OP song. That's some topical advertising. Thanks for defending Vic and due process. Also, I hope you get to do a Second Amendment stream someday. Repeal the NFA. Yeah, me too. I kind of did one a long time ago with what's his name? He's the Free Beacon Second Amendment reporter. Gosh, I can't remember his name. I feel bad. It starts with a G. Really nice guy. I recommend checking that out. I want to get a Second Amendment, like a diehard Second Amendment expert on to argue against the NFA. We're working on something like that. Sven Sorensen says, in the draft of 1917, a man from Tennessee, overseas to the trenches he went, from the land of the free. Into war he brought two things along, a rifle and his faith. Joined the ranks as a private, assigned to 338th. Cool, man. Thanks for sharing. Rick Nikita says we need to donate to the GoFundMe so we can resurrect the Emperor. Only then can we finally go after Mars Girl. Well, yeah, I mean, because Mars Girl is a greater demon of Nurgle. Clearly. I said it on the internet, so it must be true. I agree. Ink Penification. Stephen Gutowski. Thank you, Andrew. Stephen Gutowski was the guy I interviewed. You can go check out that interview. He's great. Yeah, need to do. I agree. I do want to do a good Second Amendment stream though. Ink Penification says, "Hey Ronica, how dare you call Vic something terrible? Kissing on the cheek is an Italian thing, you dirty swines." Well, we do know that Monica and Ron and Lemoyne and Jamie Markey, probably all of Funimation, they're racists, clearly against Italians. They hate Italians. Lemoyne laughed at the ethnic slur WAP. He laughed at that, thought it was funny. Which, man, that was a bit much for my taste. Forever229 says, "Did you see the video of the dreaded dance of assault?" No, I've got the video. I didn't watch it. The Kara Edwards video, right? Maybe we'll review that on stream. We'll check that out. Chris Nunez says, "Hail Rackets, today is my birthday." Hey, happy birthday, buddy. I got a glass of Aberlour 12, and I would like to ask if you and the chat would have a drink with me to celebrate. Awesome commentary and streams with the depots. Thank you for being awesome. Yeah. I'm not going to drink a lot tonight. Mainly because I have a long day tomorrow. And it starts earlier than normal. But I'll have a little bit. Let's see here. So to you, Chris Nunez, whichever one it is, happy birthday. All right. Every Game Played says, "I'd like to introduce Moron's filing to the Kevin A. Landau Center of Excellence Hall of Fame." Yeah, that'll be fun. Magic Turtle says, "Date stood me up tonight, so here's part of what I would have spent." Oh, man. Also got my Ridge wallet in yesterday and loving it. Hey, good. That reminds me. Let's take just a moment. This stream, maybe they don't want this, we'll see, is brought to you by Ridge Wallet. They did not request specifically this stream or anything like that, but Ridge Wallet has sponsored a couple of the shows. They've sponsored 5 of my shows so far. This is the second of 5. And this is the Ridge Wallet. Oh, do I have the thing? Does this even count if I don't have the thing? I think I have the thing. Where is it? Where's the For the Fans thing? No, I don't have it. All right. Well, you'll just have to trust me on this. If you go to ridge.com/forthefans, and here, we can do it now. ridge.com/forthefans. You can actually go and you can go to ridge.com/forthefans. It'll bring you to the website. If you go ahead and any purchase on the site, you can use the promo code FORTHEFANS, all one word, in caps or whatever, and it'll give you discounts and other stuff. So check that out. This is the Ridge wallet, okay? Really quickly. It's very small. It's the size of a credit card. It holds the cards in by just elastic force. Yeah. Very simple. You can load it up. You can carry several more cards in this. I took out all my credit cards since I almost showed on the last stream. I almost showed my credit cards, but there you go. This is what it looks like here. You can fan them out. Pretty simple. There's a cash strap or a money clip you can pick. I chose a cash strap, but you can actually get both. You put a money clip on the other side, but they're really cool, really nice. They're metal. You get different kinds of metals, which has different costs. And yeah, that's about it. Go check it out. Again, I'll put a link in the description to this video, ridge.com /for the fans. Promo code is for the fans. That'll give you, I think it gets you 10% off the wallet itself. I think it gives you 10% off the wallet itself. And then you can also get some other stuff with the, whatchamacallit. No, it's not an AARP card. It's a AAA card. It's a AAA card. So there you go. Anyway, there you go, guys. Go check it out. Have fun with that. And yeah, I like it. I like it very much. I like it very much. So, and I've been using mine ever since getting it. I've had it for about 3 weeks now. And yeah, don't miss my other wallet at all. So use your social security money. It's not AARP, it's AAA. It's AAA. See? AAA. All right. Anyway. Okay. All right, where were we? Intimidator 01 and 08 says, I think The Rock is going to sue for gimmick infringement, Nick. Lol. But seriously, looking forward to tonight's show. What gimmick am I infringing on for The Rock? What gimmick is on The Rock? Seriously looking forward to tonight's show. Also, the McLaren F1, Ford F-150, Raptor, and the 1970 Chevy Chevelle SS454 LS6 are my dream cars. Very cool. Very cool. Hold on one second. Oh my goodness. All right. Next, we've got, where were we? The Gun Kid says, did you know one of the people providing one of the TCPA affidavits for the alleged 2010 underage girls in hotel incident is actually in a video on Vic's Twitter laughing and having a good time with him at a con in 2016? Well, I mean, they really cared back in 2010 so much that they didn't say anything about it ever. Rockstar Dane, thank you for the donation. Didacta says, did you see the video I linked to through Gmail of Ron Toye filming up Monica's dress? The video is called Monica Rial Q&A Florida 2016 on YouTube. The exact timestamp is 1320. I did not see that. That sounds horrible. I don't want to watch anything like that. Rockstar Dane says, meant to send a message in my previous chat. However, the rum has gotten the best of me thus far. Celebrating my birthday. Hey, happy birthday. Happy birthday. Celebrating my birthday and glad to spend it here. Love you, Nick. Keep it up, my friend. Slowly convincing me to become a lawyer. Oh, God. I don't want to add to the number of terrible people in the world. I don't at all. The affiliate link to the wallet, I'm going to have to put it in the description. I guess I could do it live. Do it live. Do it live. Where is that? Okay, here we go. Let's see. HTTPS. There we go. I'm updating it right now. It's now in the it's now in the oh wait, I guess I'll do a www. There you go. It's now in the link. I told you I'm bad at selling things, right? Did I tell? I don't know if I told Ridge I was bad at selling things. But there we go. There we go. So let's see. That's Ridge. Okay, back to these things. Next 70 awesome 70 says first super chat. Assuming Miss Denbo used Monica's hotel story in her determination, Could the Stan Dolan affidavit hurt Funimation for her lack of confirming with the stated witness to see if the allegation was true? The Stan Dolan affidavit is devastating to the entire claim. It's devastated to the entire claim. She presented a fact witness. She said that he will remember. He will remember what happened. He saw me in distress. He asked about it. Stan comes out. I don't remember any of that. Much less, if I had noticed that, I would never have invited them back. So that's just a really, really odd sort of claim to suggest that this thing has no, that this affidavit isn't, it doesn't win the case. The point actually at this point in the lawsuit, everybody's kind of jumping ahead to all of these determinations. All that matters is winning the TCPA part of the case. That's what matters here. And that affidavit calls into question factual facts raised by Monica Rial from a witness that she said would support it. It just, again, well, I mean, we'll have to see. We'll have to see what the judge says. That's the best part, is that we do get an outcome. We do get an outcome on all of this. So we'll see what happens, but let's move on. There we go. But yes, to answer the basic underlying question, yes, it definitely causes a problem for Tammy Denbo. If Monica reported the hotel room story to Tammy Denbo, think about the implications of all of this in general. If Monica reported to Tammy Denbo the hotel room story, then according to everybody, Tammy didn't investigate it. She didn't mention it in her affidavit. She did not mention it with Vic on the phone with him. It's not pled anywhere. It's not part of their accusations that they've kept any track of. So if Monica mentioned it, Tammy didn't investigate it. That's a big problem for Funimation. If Monica didn't mention it, then how can she bring it now? What did she mention to Tammy Denbo? Was it just the jelly bean incident? If she didn't bring up the only thing, the thing that would be closest to some sort of actual assault, she just decided not to bring that up when she was reporting him to the employer for misconduct. And she can't use the argument that it wasn't on Funimation time or property because neither was the jelly bean incident. So where was it? This poses serious questions about the validity of the investigation. It points to a civil conspiracy between or including Tammy Denbo along with Monica, and therefore including Funimation as well, with Tammy as their agent. There's just a lot of problems with this. But we'll see. We'll see. All right, next. Dirk Lemon says, whom has the biggest gunt, Monica, Jamie, or Mars Girl? I think it's Monica. Although Mars Girl's shape is like this. So maybe it's her. I don't know. Her arms kind of obscure everything. Apollo 536 says, Mars Girl, Nurger? No, good sir. I must respectfully disagree. Look at more closely at her particular mutation. I believe you'll find this clearly places her among the ranks of Sinch. That's a good point. Very, very similar. Those extended arms. Two more, and then we're going to jump into the document. RX7FD9782 says, besides explaining long ago that running a cop off the road is a bad start for a DUI case, the most hilarious thing you've done is rustle up papers with your best Lemoyne voice. Would you care to indulge us one more? I will as I get to the document. I'll make sure and get to the document with Lemoyne in just a second. Blaine20 says, picked up a bottle of Glenlivet 12. I'll wait until I can share it with my dad while watching some STC. Star Trek Continues. And a stream by that infamous and crazy Shock Jock on YouTube. Sidebar, how does the Ridge wallet feel to sit on? It's not meant to be a back pocket wallet. It's a front pocket wallet. That's part of the joy of it being so small, is that it fits in your front pocket. That's what Monica says about Ron Toye as well. The joy of Ron I shouldn't do this. Never mind. Motion to strike that joke while talking about Ridge wallets. Ridge wallets are great. They fit in your front pocket. They don't have to go in a back pocket. They're small enough that they're non-intrusive, and they're wonderful. There you go. How's that? And guys, by the way, I will never, ever do a sponsorship deal for something I don't actually believe exists. And I will never, ever do a sponsorship deal where they actively tell me what I can and can't say. So there you go. And Ridge has not given me any restrictions, and they actually gave me very little guidance on the ad, just some suggestions on what I could do. So credit to them. And one final plug for Ridge. They sponsored this stream. They knew, they presumably knew what these streams are like, what my videos are like. It's not like this is an accident. They know that I'm pro free speech. They know that I don't accept restrictions on what I can and can't say. And for that alone, I think they merit looking at. Just check their website out. Again, the link is in the description. It's right on top. And just check that out, because that's pretty cool and very rare for a company these days to be brave enough to say, yeah, this guy might say something ridiculous. But even when he does, that's not our fault. And we think people who watch him might want to buy a wallet or a backpack or a knife or something like that. And so there you go. We've gotten another $100 on the GoFundMe. Thank you guys. All right. Oh wait, sorry. I'm supposed to. Let me pull up the documents. Here they come. I gotta get the documents. Here they are. One second. Okay. We've got Monica Rial and Ron Toye's motion to dismiss pursuant to the Texas Citizens Participation Act. So here we go. You know immediately, and you can tell the tactic of this motion right off the bat. It's in the first page. That is typically a good thing. That's typically a good thing. You want very quickly, this is a rule of writing, not legal writing, a rule of all writing. Catch your audience immediately. Set the tone. What you've got in a novel is something like 10 pages. What you've got in a short story is 1 or 2 paragraphs. What you've got in a filing in court, maybe 2 pages. The clerk's going to have to read it. The judge is going to have to pretend to read it. Either way, how well they read it will depend on how engaged they are to the content and the material. Courtney, always go with gunmetal. So this is their first page. Look at this. What is this? This is an ad, right? This isn't a document. There's no introductory language. They literally open with a picture. They're setting this stage, in my opinion, and you gotta factor your judge into it. Judge Chupp seems like a no-nonsense guy. No-nonsense guy at all. And they are starting with this. I think this is a bad move. Can never prove whether this is a good or a bad move. I will not say it definitely is or isn't. I would not at all, with a judge like Chupp, who's been very much by the book and by the rules and no nonsense up until this point, I would not lead off with a picture and this little out of context excerpt from the deposition. That is insane. That is insane. But that's what they chose, and he is a TCPA specialist, so maybe he knows. Maybe he knows. I don't know. I wouldn't do this. I think they've miscalculated on who the judge is here, but we'll see. No, Cat Lionheart, I know that a novel is on average 300 pages. I said you have 10 pages to grab the audience. Grab the audience before they just put the book down and never get back to reading it. Okay, so this is a picture. Jay posing with Mignogna in 2014. Question, and you don't kiss on children anymore? No. Do you agree with me that that's kind of creepy, right? I mean, I kiss all the children. I like to lick their faces. No. See excerpts of deposition of Vic Mignogna, Mignogna Depot. At page 145 in Exhibit 4, Jay was approximately 14 years old when she attended New York Comic Con in 2014. Has the judge ever kissed someone on the cheek? Is the judge going, like, is a normal person going to look at an actor or something kissing someone who goes to visit them, pays them money, and then poses for a picture, kissing them on the cheek, and go, rape? Is a normal person going to do that? I don't think so. When she attended New York Comic Con in 2014 and met Mignogna, she described the encounter as really, really uncomfortable. Oh, did she? She described the encounter as really, really uncomfortable, or did she describe looking back on the encounter as really, really uncomfortable? I don't remember, but I'm curious. She discussed how the voice actor put his hand underneath her zip-up sweatshirt. Notice they cropped the picture. And on her waist for the initial photo. Why didn't they show that picture? Where it's just a guy giving someone a hug, a fan, a hug. Put her hand underneath her zip-up sweatshirt. Then, thinking that the photo-taking portion was done, she was surprised when he asked her to look toward the camera again. Oh, I get another photo? That's when he put his face close to hers and then kissed her. Emphasis in the original. All right. Here's kind of where it should have started. That cover page is very weird. Very weird. Pursuant to the Texas Citizens Participation Act, the TCPA or Act, defendants Monica Rial and Ronald Toye respectfully request that this court dismiss plaintiff's amended petition filed by plaintiff Victor Mignogna and award moving defendants all court costs, reasonable attorney's fees, and a sizable sanction that sends the deterrent message plaintiff. Message plaintiff? What's a message plaintiff? Do you mean to plaintiff? So desperately needs to hear. Oh, no. Sends the deterrent message plaintiff so desperately needs to hear. Okay, so there's an implied that. Okay. Desperately, huh? Ulron1 says, the mod staff on the Rooster Teeth sites are incompetent. One of the mods on the Vic post actually believes that mods shouldn't have to make clear what bannable behavior is. And Nova Zero, thank you for your donation. Introduction. Plaintiff is a public figure, and his lawsuit is an all-out assault on Miss Rial's and Toye's. Come on. Why didn't he call him Mr. Toye? Come on. Miss Rial's and Toye's right of free speech to comment on a matter of public concern, i.e. plaintiff's conduct with children and women both in public and more insidiously behind closed doors. Problem with this. Public figure and status is a question that's a matter of law, but I don't think it's determined at the TCPA stage necessarily. So that'll be curious. But either way, we'll see. Plaintiff's case is a textbook strategic lawsuit against public participation, or SLAP. Plaintiff is a famous actor by his own admission, one of the biggest names in his field, one of the most prolific and sought after voice actors in the business. That actually isn't saying that he's the most biggest names in the field. Prolific means person who does the most work, produces the most. Or produces a lot, and sought after means that lots of people are seeking after him. That doesn't actually make him famous or a public figure under the rules, but we'll check it out. Vic has recorded hundreds of roles for animated features, TV series, and video games. Footnote 2. Oh. www.vicsworld.net. Voice. Oh, okay. Yeah. Well, I guess if that makes him a public figure, everybody who says that they're a talented and successful voice actor is automatically a public figure because they said so in their own ad. In addition to commercial and broadcast music work, Vic supervised a wide variety of private recording projects as well, from contemporary Christian to rap. There's no greater music than that which worships the creator of all music. Vic counts it a great joy and privilege to lead worship at venues around the country, having produced several praise and worship albums. Well, now, again, any traveling worship leader, Actually, just about any worship leader of a church, many of them will go to venues around the country and you'd never know who they were. So that's silly. Plaintiff's fame has long insulated him from accountability despite over a decade of reprehensible conduct. Stephen Frost says he didn't call him Mr. Toye because Ron is short for Rhonda and he's the bearded lady. Well, I just thought it was Mr. and Mrs. Ronald Toye. Mr./Mrs. In January 2019, wouldn't it be weird if Toye was gender fluid, like legitimately gender fluid? You gotta wonder. I don't know. Like, does he identify that way? Does Ronald identify that way? Is it all just subtle? In January 2019, Plaintiff had a starring role in what became one of the largest anime movies of all time, but this spotlight of international attention had the unintended effect of exposing his dark past. Commentators on social media, industry publications, and even other voice actors began discussing long-running rumors of Plaintiff's alleged pedophilia, homophobia, anti-Semitism, and sexual harassment. As the public criticism grew, studios began to investigate. Cons, conventions where voice actors meet with fans to make the large part of their living, began to disinvite him, and eventually 2 large Texas production studios publicly ended their relationship with Plaintiff. Plaintiff saw the writing on the wall and spurred his legion of fans to defend him in order to minimize any public criticism. They're lying about me. Please politely respond with positivity. Organized, spurring his legion of fans. His fans have attacked any and all critics, allied with an internet shock jock who unleashes a nightly torrent of abuse, harassment, and vitriol online. You haven't, Lemoyne, you haven't, and your clients haven't even seen abuse, harassment, or vitriol. You have only seen jovial picking. Abuse, harassment, and vitriol. Oh man, if only YouTube and other places would allow abuse, harassment, and vitriol in any capacity. God, the roasts would be so much juicier. Plaintiff's goal is clear. With enough abuse, harassment, and threats, plaintiff's accusers will fall silent. I don't know that that's the plaintiff's goal. Plaintiff's lawsuit is the hammer designed to smash Monica Rial and Jamie Markey, 2 well-known voice actors. Hey, if they're public figures like Vic is, then none of this matters, right? They're open to commentary just as much as he is, right? So we can call them pedophiles and sex addicts and sex pests and all of that stuff. We can do that. If plaintiff can silence these 2 women, 3 women, don't forget Ron Toye, those with less notoriety and power will retreat into the shadows. This case is exactly what the TCPA was designed to stop. Accordingly, the sanction imposed by this court should be commensurate with the gravity of plaintiff's actions. He hasn't done anything, and sufficient to curb his expressed intention to file more of these baseless slap suits. Relevant, factual background. What? Plaintiff's first known assault occurs 30 years ago. This is a known assault? Was this assault known prior to their statements? I don't think so. Oh my God. I read the footnote. I read the first words of the footnote. The bravery that people are displaying to speak out about Mignogna cannot be overstated. Actually, no. Plaintiff was absolutely destroyed for a straight month. By very, very brave individuals with no pushback. No meaningful pushback, we'll say. They were completely dominating the social media space. They were dominating the media, whatever joke that is in anime. They had full control over the narrative. Let's not pretend that plaintiff had anything to do with that. Plaintiff has used fear and intimidation to suppress the truth, and even now, through his attorney and allied shock jock, works to intimidate any person who thinks of coming forward against him. These witnesses are the good people who have refused to let evil triumph. Robin Michelle Blankenship McConnell, Kara Edwards, Lynn Hunt, that's Jay Montello, Faisal Ahmed, I don't know who that is, Mary Reese, Whitney Falba, Naisha Perry, Emmett Plant, that's a nobody, Adam Sheehan, Kelly Loftus, Michelle Specht, John Prager, Monica Rial, and Ron Toye. Here we go. Back to footnote 4. Plaintiff graduated from Liberty University in 1986, taking his first job at Trinity Christian Academy, leaving after 1 year. 5. See Mignogna deposition. Interestingly, his resume does not list his first job after college, Trinity Christian Academy. Where's Trinity Christian Academy? That's Florida, right? Okay. During the summer of 1989, plaintiff invited this teenager to his home under the guise of showing her a Christian worship video. 7C. Let's see. Oh, 6. So, yeah. Wait. He also had some relationship with Lynchburg Christian Academy in 1989. What relationship? Where he paid special attention to one of his students, a female high school sophomore, during the course of the school year. Notice the affidavit is from Robin Michelle Blankenship McConnell. It's not from, there's no actual evidence that he was there. They don't have Vic's testimony that he was at Lynchburg Christian Academy or affiliated with them. They don't have Vic's testimony that this occurred. They don't have anything from Lynchburg Christian Academy. They just have the weirdo who has been shown to have all sorts of problematic statements in her claim. During the summer of 1989, plaintiff invited this teenager to his home under the guise of showing her a Christian worship video. Which one? But what plaintiff really wanted was sexual relations with a teenager. See McConnell affidavit 8-9. Mignogna went into his bedroom and then came out shirtless and only wearing very small and revealing shorts. I felt incredibly uncomfortable and realized that Mignogna did not have a Christian worship video to show me. Mignogna sat on the couch next to me and began putting his arms around me and touching me. He pulled my hair out of my ponytail and started playing with my hair. Notice the theme? Mignogna also started licking my ear and stated, "Let's just enjoy each other." After several verbal rejections, I was able to push Mignogna off me and leave. Mignogna was extremely upset at me and incredibly rude. I just don't buy it. How do we even know he was in Lynchburg, Virginia? How do we know that? Where is the testimony supporting his presence in Lynchburg, Virginia in 1989? Where is anything showing his affiliation with this Lynchburg Christian Academy, which, when reached out, refuted this. When people reached out to them, they refuted that they had ever hired or would have hired Vic for this at that time. This ruse, inviting a potential victim to a secluded location under false pretenses, would repeat itself. Fortunately, in this occasion, the young woman fended him off. That's back to her affidavit. He left Lynchburg, Virginia for Houston, Texas shortly thereafter. And that's, again, she says so. She says so. Really curious. Really curious. Plaintiff spends 20 years. Plaintiff spends 20 years cloaking himself in the guise of a Christian actor and musician. This persona is far from the truth. That's going to play well. That's going to play really well. Penina Chan says, why does this motion read more like another IO9 hit piece? Did Lemoyne hire Beth Elderkin to write this? Or is Andrea trying to take lessons on being fake news? This is disgusting. I hope Chuck throws all the books at them. Guys, if you haven't figured it out, they know they're in trouble. They know they're in trouble. This is evident a long time ago. This is evident in their answer, right? What was their answer? The first part of their answer was a factual background that was completely unnecessary in an answer, and only seeked to slag the plaintiff, to damage his reputation in a publicly filed document, exploiting the privilege of a legal document. What is this? What do you think this is? They're trying to irreparably damage Vic's reputation by putting it in a legal document. That's the goal. It's been the goal the entire time. Why do you think they wanted his deposition? Why do you think they asked about a prostitute that's completely irrelevant to the case? Why do you think they asked about infidelity with Michelle Speck? That's completely irrelevant. Completely. The allegations are that Vic is a sexual predator. Not that Vic was unfaithful. That's not a defamatory statement that they made. It's that he sexually assaulted several people, including Monica Rial, Jamie Markey through a hair pull, con-slut Jesse Pridemore by being near her, and all sorts of other people. That's the allegations here. Those are the allegations that got him fired, not infidelity, not some alleged decades-old prostitution issue. None of those things have relevance to the case. Why'd they do it? Why'd they ask? All of this was intended to cause him damage. What they didn't expect was that he would own up to his mistakes. And by mistakes, I mean infidelity with his fiance, which he said he made many mistakes. A mistake being the hiring of an escort or prostitute or something well over a decade ago. Those would be mistakes that he's allegedly owned up to. They expected him to cry, to shut it down, to beg them not to show the video, to go ahead and agree to settle the lawsuit just to stop the public exposure. That's what they wanted. They're continuing the same stuff. And look at this. Plaintiff spends 20 years cloaking himself. Yeah. Plaintiff describes himself as a voice actor who has performed the voices of animated characters for over 22 years, mainly in anime productions. Footnote 11, that's going to be, from the petition. With over 350 actor credits to his name, he attends approximately 35 to 40 cons every year and derives a sizable income from appearance fees guaranteed by contract with the convention producers and from signed autographs, taking photos with fans, and appearing on guest panels. Obviously, they're going for the public figure angle here. Plaintiff is also an accomplished actor in front of a camera, writing, directing, and starring in an award-winning web series based on Star Trek, and currently filming 3 screen projects. Plaintiff's website also states that he has produced over 20 independent albums and regularly works with artists in all styles of song. And no one's ever heard of these albums. Sorry. Plaintiff has also long positioned himself as a devout Christian. His verified Twitter account has over 113,000 followers. But if he were a cat-eared chick from the UK, it would be 1.5 million. And he has a dedicated fan club called the Risen Bull Rangers, a reference to one of his most famous characters. You got that reference, but not the Führer one, huh? Perception Check says, I'm pretty sure the hair thing in Michelle's story is a new detail that she's added. How would she come up with new details? How would that occur? Maybe by reading other stories and deciding that maybe that happened. I don't know. Plaintiff's power and celebrity in the anime industry is such that few people will go on the record concerning his conduct. See his deposition and then followed by Kara Edwards' deposition. Yet everybody did. And it took nothing. Again, it took nobody to bring him down. They're going to argue later in this motion that it wasn't the defendants that brought him down. It was Han Leia, a washed up, dried up cat lady from Japan named Allison Cook, that she brought him down. A literal nobody, a literal who the F is that in the anime community, brought down this titan of power. That's going to be their argument, that Vic was unstoppable. No one in the anime community could speak out. And then this literal who's still ass mad over over him not signing yaoi art, comes out and tweets, but they're going to argue that destroyed everything. That tweet did it. Man, that's a weird case. Weird case. Those who work with him behind the scenes describe a prima donna who uses his celebrity to pursue young women for sex. Oh, okay, this will be fun. Plaintiff has a history, which he denies, of bans and or being... Produce one ban. And or being asked not to come back to conventions. Let's see, the Mignogna deposition. Yeah, I'm not banned by anybody. I get to go back all the time. So produce the history. Of those in the know and brave enough to speak on the record, prior to this dispute, plaintiff was banned from Takoshokan despite going back every 3 years. Banned from Takoshokan despite Takoshokan expressly saying we have no record of this. See Hunt affidavit. Sorry, God, that must be the liquor. The Hunt affidavit. Yeah, Jennifer Lynn Hunt. We'll see that Hunt affidavit. Anime Central Convention. Takoshokan again. Again, all from Jennifer Lynn Hunt making these claims. And where is any proof? Where is any proof of these bans? Zero. Nothing communicated to Vic. They invited him back to all of these conventions. And more recently in 2019, KawaiiCon and Anime Weekend Atlanta. According to Ahmed, he has been conspicuously absent from the RTX convention for the last 2 years, despite being one of the studio's biggest stars. This year is not a surprise. They fired him prior to the convention. And last year, again, they don't bring the same person back every year. But why didn't you get a statement from Rooster Teeth? Why didn't you bring a statement from Rooster Teeth? Surely they'd support you in this. The Takoshokan ban in 2007 is particularly troublesome considering he was stalking a Japanese singer and voice actor, citation needed, who had to move to a secret room with a security detail to keep Vic from finding her, something Takoshokan has not verified, nor has the Japanese voice actress. And B, he was also caught with 3 underage females in his hotel room. Caught by Jennifer Lynn Hunt. Prager, head of security, Falba affidavit. Plaintiff was red-faced and kept repeating he hadn't done anything wrong or done anything to them, the 3 young girls. That's amazing. One security professional that has personally observed plaintiff for years put it bluntly. This is the Prager affidavit. So here we go. Based on my personal observations, personal interactions, and professional experience and training as a security officer, I believe Mignogna is a sexual predator. He does not pay attention to the age of anyone he talks to. If he is attracted to you, he will make it known aggressively. Further, I observed a lot of encroachment into other individuals' personal space. Is that a penis going into someone? For example, I noticed Mignogna place a hand on the wall above a female's heads, touching females on the shoulders and the arms, and whispering in their ears. Is that a penis entering an orifice? I observed this behavior repeatedly with women and teenagers. Did you ask their ages, Prager? Did you ask their ages? Did you verify the age of every person he did this with? I believe Mignogna has left a string of sexual assault victims across the country. Believe based on what? Due to his celebrity status that allows him to have ample opportunities to be inappropriate. Name them. Name anyone. Name a single one. A lot of the smaller conventions put up with Mignogna because they know his fans will show up and spend a lot of money. That's weird. That's weird. Why aren't there any documented complaints? None. Can't produce them. Can you? We'll see. About these affidavits. If you think these affidavits are going to survive, I would wager all of them are going to be heavily challenged for relevancy, for any sort of ability. Like this statement is ridiculously prejudicial. There's no foundation for it. There's no There's no grounds for it. This person is not qualified to make this statement. He hasn't testified to hearing the testimony of these alleged victims. He just says, I think he probably left some victims all over the country because, well, I don't like him. Again, this is it. We're talking about highly prejudicial statements that are not probative at all to the cause of action. Not in the slightest. There's no evidence, or there's no accompanying material that would allow this statement to have foundation to be brought up. So of course, all of these things are going to be challenged heavily by Vic's team. Moreover, eyewitness accounts of his inappropriate contact with convention goers are legion. See the cunt affidavit, including giving his phone number to young girls, not confirmed, by the way. Ahmed affidavit, making cosplayers uncomfortable. Was it you? Or do you think someone was uncomfortable? Falba affidavit, requiring security guard to stand next to him at a signing table and witnessing hair pulling and inappropriate touching. Who said it was inappropriate? Perry affidavit, was there a complaint? Stroking a convention participant's leg, pulling her hair and whispering in her ear. That's from the Plant affidavit. So that's Emmett, again, talking about someone else. This is objection hearsay. They don't have it from the person who he allegedly touched. Sheehan affidavit, serial predatory tendencies. What does that even mean? Loftus affidavit, unwanted kiss, and Prager affidavit, sexual predator. We'll see this Loftus affidavit. I haven't seen it yet. Notice they didn't produce most of these affidavits in discovery, so that'll be curious. Maybe they were signed just recently. I don't know. Let's see. Okay, resulting in convention attendees lodging complaints against him. 30. Ahmed affidavit, forcibly kissing 2 different attendees. We'll have to see what those complaints are. Can they document them? Although less concerning, multiple individuals describe plaintiff as rude to staff and having a bad reputation in the anime convention community. This is a bad point for you, because maybe they have reason to lie if they don't like him for other reasons. Are we considering that? Contrary to the public persona he has created for himself, Vic's behavior reveals that he is not guided by Christian virtue. Again, this is an ill-advised line of argument, especially if that judge happens to be a Christian. That is not a good plan. Plaintiff assaults Monica Rial in 2007. Miss Rial is a rape survivor and voice actor who has worked in voice acting over the last 20 years, including with the plaintiff, including as recently as late December, with no complaints. 0. In 2007, at AzumiCon in Oklahoma City, plaintiff invited Miss Rial to his room to watch a video that she was in, by the way. As Miss Rial was distracted by the video, Vic grabbed her by the arms and began aggressively kissing her, pushed her onto the bed, climbed on top of her, and continued to aggressively kiss her while holding her down. 34. See her deposition. Notably, this is the same tactic that plaintiff employed in 1989. No, it isn't. Actually, that's not at all the same scenario as in 1989. That is completely different than what was described in 1989. Out of fear for herself and her career, Miss Rial chose to remain silent until it became clear that plaintiff had no intention of curbing his predatory behavior. Sure it did. Sure, that's when it happened. Plaintiff tries to force himself on Kara Edwards. Plaintiff's assault of Miss Rial is similar to plaintiff's attempt to have sex with voice actor Kara Edwards in 2008 and then again in 2010 at the ShadoCon convention in Tampa, Florida. This is probably her affidavit. Open the door. Nobody has to know. Come on, Kara. Nobody has to know. You know you want this. Let me be sweet to you. Plaintiff harassed and intimidated Miss Edwards, ignoring her resistance and his own pre-existing relationship in hopes of pressuring another woman into compromising herself for his pleasure. Wow. Plaintiff again attempted to corner a vulnerable woman in a secluded place. I don't know that any of this happened, but let's just suggest that propositioning a woman for sex even when you're in a relationship, and shockingly, even when she might be in a relationship, is not illegal. And you may not like it, but it's not against any rule anywhere. And it certainly is not sexual assault or harassment. It's just not. I'm sorry that it's not. Now, pressuring, what was the pressure? Was there a threat of violence? Did he prevent her from leaving? Did she say no and he somehow forced himself upon her? Don't know. Haven't read her affidavit yet. I'm going to guess what's not in there. Miss Edwards felt threatened. Did she communicate that threat and that her career would suffer by rejecting his advances? Nevertheless, she resisted his aggressive attempts to bed her. And the following day, plaintiff exacted his petty revenge on Miss Edwards by interfering with her pre-scheduled autograph signing. Oh, that'll be interesting. Miss Edwards disclosed plaintiff actions to Mary Reese on the following day. Well, where's Mary Reese? Miss Edwards has since attempted to avoid working on projects with plaintiff and has declined to attend conventions when plaintiff attends. Plaintiff has a decade. My head's low in the frame, is it? Oh, it is. The frame is different here, sorry. Thank you for letting me know. Plaintiff has a decade of admitted infidelity and consensual sexual activity in the anime industry. Consensual is in quotes. Why would consensual be in quotes? To the outer world, plaintiff represents that he was in a committed relationship with voice actress Michelle Specht, which ran from 2006 to 2018. Not only did they live together, they were engaged in 2010. During this time, plaintiff assaulted Miss Rial, conclusory, tried to have sex with Miss Edwards on 2 separate occasions, not illegal and not sexual assault, solicited sex from a prostitute. Actually, he denied that in his motion to dismiss. He said it was before he was engaged. Tried to have sex with 2 women. Notice there's no footnote there. Tried to have sex with 2 women related by birth at the same time during a convention. Also not illegal. Had at least one ongoing sexual relationship while engaged to Miss Specht. Again, what does this have to do with him being a predator or assaulting people? And made mistakes during the engagement with Miss Specht, somewhere between 5 and 50 times. Oh my God. Yes. By the way, an argument with a fiance could be a mistake. Not picking up milk from the store could be a mistake. All sorts of things are a mistake. Despite plaintiff's prodigious sexual appetite, his bizarre explanation for why people make up stories about him sexually assaulting them is they do it to get attention. That's not bizarre at all. At all. Ironically, these desperate women seeking fame by slandering Vic do so anonymously, negating whatever 15 minutes of fame Vic believes his name guarantees. Fame and attention are 2 different things, you dummy. Ass pats on Twitter are not fame. And they actually can be. Just because your Twitter account is not your name, LJ Montello being Jennifer Lynn Hunt, just because your Twitter account is not your name doesn't mean that the attention you gain from it isn't valuable, and it doesn't mean that the attention that you get from it isn't sought. Is there something about anything that you've done over the past 20 years in the voice acting community that would lend credence to people thinking that maybe you were a sexual assaulter? No. There are an awful lot of fans out there who are really desperate for attention, and they often like to talk about people to get it. If you don't think that a woman will say that Tom Cruise, Chris Hemsworth, Chris Pine, Chris Evans, all these Chris's, that they had sex with them, if you don't think they will say that just to have a story, you're ludicrously stupid. Legendary Super Saiyan Erox has caught up with videos. Can't wait to hear what the blue twat waffle Marky has to say. Could you also clarify, was Thoughtmore called a cum slut or con slut? Either way, hilarious. I'm just Super Saiyan. Lemoyne called her a con slut. CONSLUT. And so your theory is that they make up stories about you sexually assaulting them to get attention. Absolutely. Of course they do. Of course they do. Wouldn't it be better to say I had sex with Vic to get attention as opposed to say Vic assaulted me? They don't say Vic assaulted them. That's actually very interesting. That's not what they say. Oh, I'm sure, give it time. Or if you haven't seen it, I'm sure somebody out there would say that. And apparently there is at least one. I've never seen it, but it has become clear to Miss Speck that Vic lied to her throughout their 12-year relationship and that he used his fame and attendance at conventions to pursue sex with as many of his young fans as he could. 48. See Speck affidavit. You systematically targeted dozens upon dozens of fangirls, most at least half your age, with whom you first built trust, some over long periods of time online, some in a manner of minutes in person, and made each one feel so very special and chosen with the endless charm, attention, and mask of sincerity that abounds when you want something, seduced them, propositioned them, and turned them into convention XXXXX. Doing so in every city and every country you went to, calling me afterward like you always did before you went to bed, sometimes with them still in the room. But you loved me, right? Listen to how this reads. This is a terrible plan for an affidavit. This is terrible. This woman is clearly motivated to lie. She's hurt. She's hurt. She should be hurt. She is hurt. And it's not going to come across the way they want it to. You used your STC and con buddies as regular wingmen at conventions to help arrange these hookups. XXXXXXXXX. Your way from one cosplayer to another. Oh, these are naughty words. One group to the next, telling each one, I don't usually do this. There's just something about you. Convincing them you didn't need to use condoms because, hey, you're the only one, or don't worry, I'm taken care of. After which you would come home and slip into our bed beside me as if nothing happened. But you loved me, right? This is a terrible plan for this. They should have cleaned up this affidavit. This is a bad affidavit, if that's how the rest of it reads. Oh my God. Notably, when plaintiff responded to Ms. Speck from a different email address, he did not deny the allegations. Oh, these are from not from her. No, that's from the affidavit. From a different... Why is he talking about emails? Did they do this weirdly? Okay, so the Exhibit A is the... They must be referencing in the affidavit an email. Still, that's not going to come across well. I don't think that's going to play the way they think it. Vic has no words to express his shame for his conduct. Except for the words where he says, I don't actually do that at conventions very often. I mean, the exact opposite of what you said here, and left that out. On January 16, 2019, and again, can Michelle actually produce any of this? Can she produce that this actually happened? I mean, aside from him cheating on her, can she produce these circumstances that she's laying out? Or is that the fantasy in her head? Is that how it played out in her head? January 16, 2019, plaintiff's long history of alleged sexual harassment, pedophilia, and homophobia, apparently, and sexual harassment. One of Vic's most popular characters, Broly from the Dragon Ball Z series. And conveniently did not include the email from Ms. Speck in his response. Oh, okay. So petition. On January 6, On January 6, 2016, a new Dragon Ball movie titled Dragon Ball Super Broly premiered in the United States, earning $7 million on its first day and $24 million within the first 5 days of its premiere. That's from the petition. To date, the film has grossed over $30 million in the U.S. and more than $88 million worldwide. The same day as the premiere, someone with the Twitter handle Han Leia accused Vic of being a homophobic, rude a-hole who has been creepy to underage female fans for over 10 years. That same user tagged Funimation with the question, hey, Funimation, why do you employ a known pedophile? Known pedophile isn't actually real. And a link to allegations of sexual misconduct by Mr. Mignogna at anime conventions. So that's from Funimation's motion to dismiss. The thread quickly spread with over 4,000 retweets and over 400 comments, many relaying their own negative experiences, including unwanted and unsolicited physical affection from plaintiff. God, I wish they would have included all of those things. That would be interesting if they did. This is not at all surprising, as plaintiff admits receiving criticism for years for kissing young girls and acknowledges rumors of pedophilia dogging him well prior to January 2019. Yeah, lots of people have rumors of pedophilia, like you, Jay Sean. There are rumors of Jay Sean's pedophilia floating around on the internet. Same with Ron Toye. His decade-long run of infidelity while in a relationship with Michelle Specht obviously did not help matters and has no bearing on this case. Plaintiff weaponizes his fan base and issues several self-serving statements to spin the narrative in his favor. As allegations of misconduct intensified and perhaps realizing the social climate no longer supported his behavior, on January 19th, 2019, plaintiff arranged an online chat with the Risenbull Rangers. See Mignogna deposition. This is similar to what plaintiff did in 2010 when he hosted a rumor panel to spin up his fans to defend him. To address rumors about him. That's spinning up. What is spinning up? The instruction was clear. Do whatever you can do to counter all these lies and negativity. Yeah. Please. Please. People are lying about me. Lies. Weaponizing his followers is a tried and true tactic for plaintiff, happening allegedly twice over the span of 9 years. For years, plaintiff has hosted what are in the anime community referred to as rumor panels. One, according to you, in which he seeks to dispel rumors about himself that are upsettingly similar to the communications at issue in this dispute. For example, in July 2016, plaintiff told the assembled fans at Animazing in Davenport, Iowa, that women who made allegations against him are merely unimportant people seeking attention that do stupid, mean-spirited, hateful things just to get attention, all because they want somebody to notice them. That's not a rumor panel. That's just a statement made at a panel. If somebody was sad and lonely and felt unimportant enough and was so desperate for attention that they thought, I'm going to say something about somebody that a lot of people know just to get some attention. Yeah. Brian Duig says, Ty mentioned a counter TCPA claim, but that he probably wouldn't file it, depending on what they did. What is a TCPA counterclaim? Okay, Ty was probably joking, but partly serious, because the wording of the TCPA, the wording of the statute, would include filing a TCPA against a TCPA, which is a legal action that seeks relief that goes against your right to petition. I know a couple people on Twitter tried to make fun of that, but it's actually happened. And the Supreme Court of Texas has commented on it, calling the person who tried it a clever litigant. Clever litigant. The wording of the statute actually allows this. Now, I don't think he's going to do it. Maybe he will if he's a madman. That'd be kind of funny. But the wording of the statute allows it. So there you go. I mean, I think the better... I think he followed up with saying, I don't think Judge Chupp likes games like that, though. All right. On January 19th, 2019, he sounded the call to arms for the Risenbull Rangers. Plaintiff explicitly refers to his hugging and affectionate demeanor, arming his supporters with what continues to be his main defense. His accusers are desperate liars. Yes, he has maintained the entire time that people are lying about him. He's maintained for years. Oh, and by the way, his accusers would know, right? That he's maintained for years that this is all lies? Huh. That'd be interesting. He calls the allegations against him absurd and baseless garbage leveled by a tiny group of detractors, as if the allegations would have more force had there been more women coming forward. That's literally your client's argument, you dumb pile of garbage. That's literally the Toye and Rial argument, is that there are so many women that it must be true. Oh my God. There's so much in this motion that I hope will just get rammed right down the throats of these people because this is stupid. It's stupid to argue this. would have had more force had there been more women coming forward. You not only your clients, you made that argument before that his power has kept people out, but now the volume of brave women suddenly speaking up suddenly makes it okay. Suddenly now people listened. You've argued the exact opposite of this in this document. And again, he instructs his supporters to do whatever you can to counter all these lies and negativity. I think that's not an accurate quote. I think it was with positivity and goodness, but I don't remember. Let's see. With his legions ready to pounce and armed with talking points, plaintiffs issued an apology the following day, the January 20th apology, to address years of rumors concerning his homophobia, anti-Semitism, and accusations of sexual harassment and pedophilia. Finally, any allegations of sexual harassment, sexual assault, or most disturbingly pedophilia are completely and utterly false. My heart weeps for anyone who endures a violation of this kind. So to be accused of harming other than this way, I have no words. This doesn't help you. He's maintained for a decade that the allegations are false. No action has been taken on him for a decade. This doesn't help your case. The apology fails, and numerous articles outline what insiders have known for years. How'd they know it? The attention from Dragon Ball Super Broly, along with the ensuing firestorm online, no doubt exacerbated by Plaintiff stirring up his fan base. Why didn't you just lay down and die and accept it? In turn, launched a series of online articles recounting in excruciating detail the long history of Plaintiff's poor reputation. January 25th, 2019, Polygon.com, Dragon Ball Super Broly voice actor responds to sexual harassment and homophobia claims. Many convention goers' stories continue to come out on social media. Many convention goers detailing times when the actor acted flirtatiously toward them, fondling, kissing, groping, etc., without their consent, most while they were still underage. While these allegations are only just picking up steam, it's undermined in the freaking article that you cited, only just picking up steam. Many of them go back as far as 2010, but they're only just picking up steam. In addition to the sexual harassment claims, Mignogna's alleged homophobic behavior remains a concern with anime fans. Let's see. David Redondo says E.L. James. 10 out of 10, E.L. James would steal. Stoked about Eisenhorn show. I would be more stoked for Gaunt's Ghost. Taineth first and only. I think Eisenhorn will play better than Gaunt's Ghost, mainly because it's so character focused, and so they don't need as much cast as Gaunt's Ghost, or as much blood. KCC says the tactic seems to be to flood the zone with lies and hyperbole and hope the judge is too bored, overwhelmed, or tired to see through it. Disgusting. Yep. You've got it nailed, buddy. That's exactly what's going on. Doom Guy. Oh my goodness. See, Streamlabs is screwing me over here. Hold on. Let me, very, very frustrating. Okay. Owner on your knees B says, completely hypothetical question. If a citizen of the great state of Minnesota was found to have married a sibling to cheat immigration, committed bigamy, tax fraud, and perjury, what kind of charges would they face? Whew. I could not tell you off the top of my head. Wait a minute. Are you referring to a congressman in the state of Minnesota? That'd be interesting. Doom Guy says, Nick, can Kick Vic use the TCPA document to further have Vic banned from cons? Also, please Minecraft yourself low T Greg. I mean, they can use it however they're going to use it. Jadolph Lemois Esquire says, in Jadolph voice, he sued my client, her fiance, the whole company over a cartoon thing, and his career, and you think he will stop now? Mr. Vic is a man of focus, commitment, and sheer effing chadness. He once satisfied hundreds of women at an anime convention with a single jelly bean. Who the F can do that? I can assure you that the stories you hear about this man, if nothing else, have been watered down. Thank you, Jadolf. Thank you, Jadolf, for that. Very much appreciated. And from Blaine20, in news anchor voice, counsel for Mignogna has reportedly launched a TCPA missile at defendants in response to theirs. Missiles expected to strike both sides, guaranteeing mutually assured destruction. More at 11. There you go. Hopefully that was satisfactory for you. January 30th, 2019, Anime News Network. Far from perfect, fans recount unwanted affection from voice actor Mignogna. A Twitter thread posted on January 16th accused dub voice actor Vic Mignogna of homophobia, rude behavior, and most concerning, making unwanted physical advances on female congoers. February 1st, the Tao of DragonBall.com/blog. Fixing the staircase, Vic Mignogna's sexual assault allegations and the voice actors who speak out. Vic Mignogna, the voice actor of the voice of Broly in Dragon Ball Super, has been accused of sexually assaulting women at anime conventions. However, numerous allegations of sexual assault have shadowed Mignogna's career and continue up to today. During the research for this article, over 100 independent allegations surfaced dating back to 2003. Let's see. February 19th, 2019. Gizmodo.com, one of anime's biggest voices accused of sexual harassment. Stories about Mignogna have been circulating online for over a decade, including through the Tumblr blog, that's not circulating, Dear Vic Mignogna, but the latest round of accusations started surfacing around mid-January of this year. IO9 spoke with more than 25 voice actors, cosplayers, industry professionals, convention employees, and former fans about their experiences with Mignogna, and selectively left out several accounts. Many of them asked not to be named in fear of retaliation from Mignogna or his fan base. Oh no. Unbeknownst to the public at large, Funimation conducted an investigation into plaintiff's behavior. Was it unbeknownst? Including interviewing Miss Rial and 3 others, found his explanations unconvincing and quietly terminated its relationship with him on January 29th. 2018. That's at 71. So that's see the Mika affidavit. On or about January 29th, Tammy Denbo reported to me and Trina Simon that Miss Denbo had found that certain allegations of inappropriate conduct made against Mr. Mignogna were credible. That's not what he says here. Found his explanations unconvincing is very different than saying that the certain allegations were credible. Let's see. Plaintiff concedes, as he must, the foregoing articles are defamatory and damage his reputation. Yep, that's not fatal to this case at all. I'm not going to read his stuff. Oh my God, that was stupid. That was a stupid line of questioning. Plaintiff's poor reputation in general, refusal to acknowledge that kissing children is improper. Who says that kissing in a completely non-sexual way is what you're leaving out of there? Children is improper. Do you kiss children on the cheek? Do you kiss your children? What about your nieces and nephews? What about your friends' kids? Give them a kiss goodnight on the cheek or something, on the forehead? What about a kid that you visit in the hospital, Lemoyne, while you're in there for your West Nile treatment? What about that? Nice kid sitting there, asks you, I want to be a lawyer when I grow up. I'm 11 years old, in the burn ward, laying in my bed, and... J. Sean Lemoyne kisses child in bed. I mean, this is ludicrous. It's ludicrous. Twitter firestorm and defamatory articles take their toll. 2 major anime studios terminated their association with plaintiff, causing to lose multiple conventions by February 6th, 2019. On February 5th, 2019, anime studio Rooster Teeth publicly terminated its relationship with plaintiff. Between January 18th, 2019 and February 6th, 2019, plaintiff lost 10 convention and invites. February 11th, Funimation publicly terminated its relationship with plaintiff. Plaintiff sends a faux apology to Miss Rial to set up and generate sympathy with a public apology. Can the chat help me out with this? Wasn't there an article on like January 29th from Anime News Network or January 30th, alleging that Vic had been released from Funimation. And wasn't it confirmed by Funimation, or was it unconfirmed at the time and they were waiting on a response? I'm pretty sure there was an article that Funimation had fired him on January 30th. That information could have only come from Funimation. February 8th, 2019, plaintiff sent an email to Miss Rial under the guise of wanting to know what he did wrong. I mean, I guess. Notably, plaintiff contends even at his deposition not to know what he did to Miss Rial. It's almost like he's been consistent the entire time. Yeah, Chad is saying yes to that article. So again, we've got disingenuous stuff going on. Who provided that information? Who provided it? Let's see. Yeah, notably, I am embarrassed to say that I honestly don't know. I hope you will share it with me so I may sincerely apologize. No one should expect an apology, sincere or otherwise, from plaintiff. Why would you put that in there, you dumb fucking idiot? This is insane. This is insane. No one should expect an apology. Your clients have asked for apologies and said that him making an apology would bring him back into the anime community. They've said it privately. They've said it publicly. Why on earth would you add this little exposition in your footnote? The judge should hammer you on this garbage. But you're not doing this for the judge, are you? Because you know how the judge is going to rule in this case. Notably, he did not send an apology to the other 3 women who were part of the Funimation investigation. He didn't apologize enough. He didn't do it enough. February 13th, 2019, 2 days after Funimation's public termination, plaintiff issued another Twitter apology in which he stated that it was not his place to contradict people if they claimed that he had made them feel uncomfortable. He said he couldn't know the minds of other people. But at this time, plaintiff specifically drags his colleagues into the public fray. Okay. An amateur, I am a professional internet shock jock. Am I a shock jock? I don't think so. What is I don't even know what a shock jock technically is, but we'll take it for now. Injects himself, like you would love to, Lemoyne, into the controversy and raises over $225,000 to help grind the defendants into dust. Nick Rekieta, an internet shock jock. Well, I mean, I'm a lawyer. I'm a journalist, is a Minnesota resident who manages a channel on YouTube and is allegedly a practicing lawyer. I mean, you can look it up. I'm a member in good standing. I'm admitted to practice law. I'm current on my continuing legal education, and I do still practice law, as stated over and over and over again, although I'm trying to practice as little as possible. And journalist. Let's see what the Führer says. Rekieta does not appear to have any relevant experience in defamation disputes, nor unsurprisingly any investigative journalist credentials. I mean, I've been reporting on legal matters on YouTube for a year and a half now, more than a year and a half, coming up on 2 years. What credentials do you, and I've amassed quite a following in doing so. So, what credentials do you need, pal? I've actually got more journalistic credentials than many recognized Twitter journalists who have blue check marks and smaller Twitter followers, no YouTube presence, and publishing in articles like Anime News Network that no one cares about. Sometime in February 2019, allegedly out of the blue, this shock jock contacted plaintiff directly to express his support for Vic's plight. 81. See Mignogna deposition. The exact genesis of this relationship between plaintiff and shock jock is unknown because plaintiff, even after this litigation began, has a pattern and practice of deleting relevant text communications. Did you send him an evidence preservation request? Did you do that? Did you send a request for document production? On February 19th, 2019, Rekieta set up a GoFundMe campaign. Uh-oh. We got to pull it up. Here we are. GoFundMe campaign, 230,320. Last donations by Ben Schouler and Daniel Zapata. The refund was on the prior one. So thank you, Ben Schouler and Daniel Zapata, for contributing. Thank you so much. I'm sure we'll be doing that a lot in the next couple minutes. If anybody wants their name read, now is the time. GoFundMe campaign for the purpose of funding lawsuits against many possible defendants, including bloggers, corporations, and pseudo-anonymous keyboard warriors. The GoFundMe War Chest 82. I love how he has branded it the GoFundMe War Chest. Okay, here we go. Perception Check says ANN's article dropped on or around the same day Rooster Teeth announced his termination. Thank you for that. Trashtown TV says it still blows my mind how eating a jelly bean, touching hair, innocently kissing fans on the cheek, and requesting love from women is enough for these goofballs to label Vic as a sexual predator. Well, that now you're a sexual predator too. We are living in clown world. Bradley Wykes says in the footnote, the name Mika was mentioned in an affidavit. Is that one of the 3 redacted names? No, Mika is one of the She's one of Funimation's employees, and her affidavit is from the Funimation one. Let's see. Hold on. What is this? Oh, sorry. Sorry, I was making sure that wasn't breaking news. Gunnar Renee Oy says they called you a professional journalist. They did? I didn't see a professional journalist. Where did they call me a professional journalist? Anyway, let's go back. So then they've got the GoFundMe's words here. The GoFundMe words here. This fund is set up for Vic's legal defense fees. There are many possible defendants in different jurisdictions, from boring bloggers to multi-million, even multi-billion-dollar corporations. And remember, Vic said, not yet, when asked if he had sued anyone else. It takes an agile and experienced, not cheap legal team to coordinate this kind of strategy. I am not representing Vic in a legal capacity. Giant caps. But I am aware of the team who is and will coordinate this fund to pay for Vic's legal fees. Litigation costs are highly dependent on the actions of your opponents, so I'm hoping to raise enough to account for that. We will announce a disposition of any extra funds candidly and provide updates on the usage of funds to the extent that such information can be made public. But it's time to fight back. Brigades of pseudo-anonymous keyboard warriors cannot be allowed to defame and destroy decades of goodwill on rumor and unverifiable allegation. Companies cannot rely on non-credible accusations and devastate a career for virtue points. This last sentence, juxtaposed against the rumors and evidence cited herein about plaintiff, you just called them rumors, irrefutably demonstrates Shock Jock's lack of prior investigation into plaintiff's reputation in the anime industry. It also undermines any assertion of credible investigative skills. Hey, Jay Sean, let's talk credible investigative skills. You couldn't be bothered to look up my public mailing address that's listed on literally every video that I've done in the past, 6 months. My 6 months, 5 months, 4 or 5 months, somewhere in there. All of the Vic videos that I've done, that ones that you're citing, my address is right there. My public mailing address. Couldn't look that up. You couldn't look up my publicly available email address. Instead, you sent it to a different email address, whatever you tried to email. And I don't have access to that email account. So I'm not sure why you sent it there. You couldn't be bothered to click on the description or scroll into the description of the videos that you're citing in this document to find my address and my email address. Couldn't do that. You couldn't be bothered to check the Minnesota court filing system to find records of cases that I participated in. Instead, opting to use Pacer when I don't practice federally, which you would know with any investigative skill. I'm not even licensed to practice in front of the federal bar. Never needed to, never really wanted to. And or in any federal jurisdiction, I should say. And you couldn't be, and also looking at Westlaw, and suggesting that you couldn't find any cases on there. Well, no, I don't have many cases on Westlaw. Although it's interesting that the guy who you're going to suck the dick of for a lot of these pages, T. Greg Doucette, only has 3 cases on Westlaw. And he, according to himself, has personally litigated over 1,000 cases. So out of 1,000, he gets 3. And you suggest that I must not be practicing law because you can't find it on Westlaw. And you can't find it on Pacer, where you would never possibly find any case that I've litigated on Pacer, because I don't do federal practice, again. And you couldn't be bothered just to check the Minnesota court system to find my cases. Now, what's interesting is that non-legal professionals on Twitter did this a long time ago, probably about a year ago, and they found it just fine. Whose investigative skills are bad here? Now let's further assert that this is a defeating argument, self-defeating, because maybe it's not my investigative skills. Maybe if you go back and look at the archives, when they actually occurred back in February, of websites that you've cited, that you have disingenuously cited, like Pretty Ugly Little Liars, you'll find out that those rumors on Pretty Ugly Little Liars inflated dramatically after April, or after March, maybe even April. I think it was after April 18th that they really started to pick up. But certainly after January. Certainly after February. And you can check the archive links. In fact, I would hope that Mr. Beard will be including the archive links showing that at the time of the defamation, when you're trying to use pull as your source for your dumb client, Toye, at the time of the defamation, pull didn't have much on it at all. Not much at all. That all came later. And it's an ongoing circle jerk. Or maybe he'll show the prior versions of Anime News Network's articles where they had to retract and their use of photos without consent and in contravention of the subject of the photos' stories, where they said, actually, no, this is not what happened. Anime News Network literally lied. Maybe if you had any investigative skills, you would know that. We'll see. We'll see, buddy. That's going to maybe come back to bite you. Also, you really don't want to know what I've gotten with my investigative skills. You really don't want all of the information that I've acquired that I can't necessarily release yet, my friend. You don't want that. Believe me. Believe me. February 20th, 2019, plaintiff told his 113,000. That's a lie. He didn't have 113,000 Twitter followers on February 20th. That he approved the creation of the GoFundMe war chest. Plaintiff acknowledges that his previous statements had been intended to silence his critics, but that he failed to do so. He wanted the defamation to stop. And so he sent out apologies. He made statements saying that this isn't true. That's not an attempt to silence your critics. That's an attempt to stop people from lying about you. Plaintiff refers to Rekieta as a friend and directs his dedicated fans to donate their funds for his retaliatory lawsuit. It's not retaliatory. It's offensive. The motive for the GoFundMe war chest as explained by Shock Jock. Shock Jock. He did not put Shock Jock in parentheses after Rekieta. He shouldn't be referring to me in this way. Here's my words. There are hundreds of hours of video of my motives for contributing to the GoFundMe war chest. Of creating it, not contributing to it. The biggest one is I just don't like any of the defendants, and I think that they're terrible people. Let me say again, I don't like any of the defendants, and they're terrible people. And part of the reason, a big part of the reason that I was motivated, self-motivated to create the GoFundMe war chest is because I am tired of the Me Too garbage, taking people down without investigation or without evidence, without verifiable claims. I'm tired of it. And I think that people who do it are disgusting piles of trash. They come out, they have no evidence for their claims, absolutely none. They have nothing they can do to produce any witnesses. Everything all happened years and years ago, behind closed doors. They lied about it for decades, apparently. Monica Rial lied by omission about this incident for 12 years. But now it comes out, just suddenly, out of the blue, and we're all supposed to just believe it, take her word. We're supposed to believe that for 12 years she was lying, but now she's not. And then, because of that, a man has to lose his career, lose his fans, lose his friends, lose his life. That's what Monica Rial wants. Let's put it out there. Monica Rial wants Vic Mignogna dead. She wants him dead in the ground. I believe that 100% because I believe that Monica Rial has known Vic long enough to know what this would do to him. Monica Rial wants Vic Mignogna dead because she's a dumb, scandalous, nasty bitch. And I hate people like that. And I do want them ground into dust. And that's me. And no one else gets to claim my motive but me. And the best part is, it doesn't matter at all what my motive is, does it? I can want to help you for any number of reasons, Jay Sean. That's amazing. Doesn't matter what my reason is, only matters what Vic's reason for bringing the suit is, doesn't it? And I never told him my reason for doing it, other than I think he's innocent. I mean, there's that. There's that other reason that you're leaving out. But here we go. And I want to see them ground into dust because when you lie to take away a man's livelihood, you deserve to be ground into dust. You are scum and you know it. That's why I created it. Absolutely. 100%. Come depose me, I guess. Capitalizing on the sensationalism of this dispute, Shock Jock has used his YouTube show mainly to generate money for himself. Yes, my show is a for-profit endeavor for myself. Has been for a long time, long before the Vic thing. And secondarily, not even close, to threaten the disclosure of personal information of any witnesses hostile to plaintiff. Listen to how disingenuous this is. Listen to how disingenuous this is. Hey, pretty ugly little liars. I know you're watching even though you're never, ever understanding. But just in case you don't realize what that means, what that, in brackets, is Casey Eric going before a judge saying we want everybody's name public. We don't want any confidentiality. I am dumbstruck at Casey's stupidity here. Also, Casey goes back on this claim like a week or two later and tries to get, this privacy that he said he didn't want. So anyway, is that if any of your identities are discerned by the court, it might not even be me. It might not be me. It would be the court. The people who have doxed the most people in this lawsuit are the defendants. Is that, yeah. It might be Casey leaking them to Shane that makes them public. That happened to Jamie Markey. That happened to Jamie Markey's address. That would be a real shame. And it would, wouldn't it? That would be a real shame if, like your workplace, like let's say there was someone who emailed a convention or a signing event or something, and it was easy to ascertain where they worked. Like imagine what happens when a person who goes out and lies about someone to get their job ruined, that person's email and workplace gets exposed to the internet. Yes. What is wrong with this statement? It's the weirdest thing on earth that they would ask for this. It's the weirdest thing on earth that they would ask for this. Me saying that is somehow a threat. Oh my God, the disconnect. The disconnect. True to his word. Now notice how they do this. Rekieta's and Vic's fans. Not Rekieta and Vic. Not Rekieta or Vic. Apparently, Vic's fans and my fans have embarked on a terrifying campaign of harassment and threats of defendants and several witnesses. Yeah, name one. Name one that you can verify. This combined with plaintiff's intent. So they apparently have a citation for that. Ahmed and Plant. Plant, Emmett Plant, begging for attention for days and days and days on Twitter, just constantly. Somehow, Emmett Plant tweeting like 200 times about this thing is my fault that people looked him up, and he over and over states that he's public. I still don't know anything about Emmett Plant other than that he's got a sexual fan fiction about Vic Mignogna that he's published in a blog, that he has promoted that blog. If you want anyone looking for attention, he has promoted that blog post for 3-4 months now. Just read my blog. Please read my blog. I'm neutral. Just read my blog. I don't want anything to happen to Vic. Vic's my buddy. Just read my blog. Over and over again. And that he's some sort of writer or producer of some Star Trek, which I don't watch. So I guess how, again, the lunacy. How am I harassing or I've never even spoken to Emmett Plant. I've tweeted to him about 3 times, and it was always, oh my God, every time you come up in my mentions, I get like 50 notifications of you promoting your stupid blog. Shut up, you moron. Anyway, this combined with plaintiff's intent to sue others in the future, which he has a right to do, by the way, the right to sue is a strongly protected right. You can petition the government for redress of grievances from your citizens, and that is absolutely protected. You can threaten that you're going to sue people so long as you have some sort of intent to do it. You don't even have to carry it out. But if you actually honestly intend to do it, you can threaten to sue people, and they cannot say that your use of a lawsuit is somehow absent a finding by the court that it was frivolous or vexatious, that your use of a lawsuit is somehow some sort of bludgeon. Courts have held over and over that the right to bring a lawsuit for perceived damage is protected and privileged. So has created a toxic public debate. Oh, no. Your clients created the toxic public debate. Your clients. If you just would have shut up, right? If no one would have ever talked about this, we could have just said what we wanted, and then no one would have to answer for anything. Instigated by plaintiff and his online proxies. Prior to filing suit, Vic's friend proposes an agreement to avoid litigation. So this is Chuck Huber. Now, this is really disgusting. Really disgusting. Plaintiff will publicly declare himself a sex addict if Miss Rial and Miss Markey will recant. Huber proposed that. Vic had nothing to do with it. Hey, Chuck, buddy. If you're out there, man, these people are using your attempted goodwill against Vic and you. And you. You think these people are your friends, man. You tried to mediate between both sides. Look what they did with it. Look what they did with it. On March 6, 2019, plaintiff's longtime friend Chuck Huber, whom plaintiff claims is a truthful person. Oh, that's disgusting. That's disgusting. Floated a proposed statement that plaintiff would issue in exchange for Miss Rial and Miss Markey, effectively recanting their public statements. That is disgusting of them. From Vic Mignogna. My name is Vic Mignogna and I am a sex addict. Underlined. Again, Vic didn't write that. Vic didn't agree to it. None of that came from Vic. Addict behavior is by its nature, is hurtful and mostly unseen by the addict. I'm working with a therapist to understand my addiction and to get healthy. I have never intended to hurt anyone, but it's so obvious now that I did. To the people I hurt, there are no words that will suffice. All I can say is that this experience has permanently moved me toward a better path. I'm doing my best to be a better person. I'm sorry and will make amends wherever possible. To the fans who continue to harass and threaten, you are not my fans if you do this. Again, this is a proposed statement by Chuck Huber. Nobody at all from Vic's side approved this statement or had input on it. Actually, I'm pretty sure Chuck did it without even asking Vic. That would be bad. Your behavior needs to change every bit as much as mine does. Like me, you should be given the opportunity to change. I am working every day to be the same on the outside as I am on the inside. I only ask for the opportunity to demonstrate that I've changed and to continue the work I so dearly love. I'm canceling my appearance at Anime Matsuri and I'm taking a leave from all convention appearances until, in conjunction with my therapist, I'm ready to come back. I will take my recovery and return one day at a time. Emphasis added. No kidding. No kidding. Plaintiff admits to seeing the email but not authorizing it to be sent. Well, that's just a nice footnote, isn't it? Huber even references the legal team as requiring a statement from Miss Markey and Miss Rial and the belief that the shock jock would be on board. Let's clear that bullshit up right now. Go ahead and pull this up 1 second. First of all, by the way, guys, don't help your friends in legal matters in this way, ever. That's horrifying. Horrifying to do this, to do that. I posted this on Twitter. Whoops. That was me. That was my thumbnail. High quality thumbnail. Let's posted this on Twitter, but let's be very clear what Jay-Sean is lying about here. He is flat. Jay-Sean Lemoyne is lying to the court again. Again. Let's read that. Here we go. Huber even references the legal team as requiring a statement from Miss Markey and Miss Rial and the belief that the shock jock would be on board. Why would he say that? Chuck Huber never once talked to me about this. Not once did Chuck Huber talk to me about making any sort of statement or doing anything. You know why? I'm not on Vic's legal team and never have been. You lying sack of West Nile ridden shit. You're trying to use the words of Chuck Huber to impute the words of me onto Vic, and that's disgusting because you're lying about how they came about. Monica Rial writing to Chuck. Hey, Chuck, I hope you don't mind that I've CC'd Jamie on the email. Does he realize that all of this could have been avoided if he had just released this statement in the beginning? I don't know if Chuck even told Monica that he drafted this statement to give Monica slight benefit of the doubt. Notice they never asked. Here's what I don't understand. What is our part in this? Oh, he's got a statement for you too. If he releases his statement, what does that mean for us? That he'll drop any and all suits? I would need to know that before I agreed. If that's the case, I would love to make this work. Here are some things we would need though. A statement in writing stating that he would not sue us or employers at a later date. A public first of all, oh my God. Clearly advised by counsel at this point in time. A public apology from Nick Rekieta for the name calling and harassment. That's what Chuck Huber is saying would be on board for, you disingenuous prick. And no, he didn't ask me, and I would never, ever in my life apologize to them. Not once would I apologize to them. If Vic came to me crying on his knees, asking me to apologize to Monica Rial, I would say, fuck Monica Rial. I will not apologize to them. And you know why? Because my words are not Vic's words. They never have been, and no matter how hard you want to pretend that they are, they're not. And I've said openly, he wouldn't approve of what I say. And that's how I like it. Why in God's name would I need someone else to tell me what to say on my own show, you idiot? You clearly have great investigative skills if you can't figure that out. All right. So, moving on. Not Ghibli says people are trying to be funny with the names on the GoFundMe again. Read comments instead of names. No, I'm not going to encourage anything. Trashtown TV says, I'm sick of the hashtag #MeToo crap too, Nick. My best friend, Silent Rob, has a brother who was falsely accused of sexual assault, but the authorities bullied him into a confession. This is why I donate. This nonsense needs to stop. Oh, I didn't. Did I get the GoFundMe again. Oh, I forgot to bring up the GoFundMe when he said it. Hold on. You guys didn't. Well, I didn't see you mention that. Let's just make sure. We're at 320,725. Brian Farrer, Dennis Chang, Daniel Pareo, Herd Barris, Anonymous Bandit, Jacob Johnson, Gary Covington, fourth donation, first by name, Your Journalism Credentials, Stacy Dealman, and Julian Fondren. Thank you guys for the donations to the GoFundMe. I'm sorry that I missed bringing it up when he mentioned it a bit ago, but there we go. All right, so back to it. Miss Markey and Miss Rial refused to agree to the proposed statements because they were untruthful. What do you think? Why do you think Vic refused to agree to the proposed statement? And they refused even though Huber previewed the vicious online assault that plaintiff would unleash. And please don't mistake this as some weakness on their part. This is my efforts to try and stop something I know will be very damaging. They have a full court press prepared that is not a minor effort. They will be extremely thorough in both the legal and social spheres. I think Ty had said he was wanting to fight this fight in public, right? That's Ty. So there we go. And you know why Ty would want to fight this fight in public? I mean, I can infer it's because they fought the fight in public. They chose to do this in public. So instead of Vic crawling under a rock for 2 years while this case wallows outside of everything, his legal team has decided to fight the fight in public. By the way, so have you guys. Stop lying and pretending that you're not talking about this case for the past 6 months. Talking about it constantly. There are constant tweets from Ron Toye referencing this case, referencing how you want it to be public, referencing how you're not afraid of court, over and over, referencing the evidence that's coming out or not coming out, talking about court. You guys are talking about court constantly in public. Don't pretend that you're not. Kazma says, I know lawyers do what they got to do for their client, but this is vile. How much of this do you think is Jadolf as opposed to the thing Moron insisted upon? Oh, I think it's both. If you get deposed, try and read some names from GoFundMe to Jadolf's face. Arguments and authorities. Applicable standards under the TCPA. Oh, now we finally get to the thrust of their motion after 18 pages. The stated purpose of the TCPA is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of a person to file meritorious lawsuits for demonstrable injury. I don't know. Does Vic have demonstrable injury? Yes. Then the question is, does his lawsuit have merit? Of course it does. Of course it does. Because the TCPA provides a procedure for expeditiously dismissing a legal action that is, quote, is based on, relates to, or is in response to the party's exercise of the right of free speech or the right to association, courts construe the TCPA liberally to effectuate its purpose and intent fully. The TCPA defines exercise of the right of free speech as any communication made in connection with a matter of public concern. A matter of public concern means any issue related to health or safety, environmental, economic, or community well-being, or a government or public figure, or a good, product, or service in the marketplace. Of course, the TCPA is going to apply to defamation. And like it just is. TCPA broadly defines communication as the making or submitting of a statement or document in any form or medium, including oral, visual, written, audio-visual, or electronic. TCPA does not require that communications at issue specifically mention a matter of public concern or have more than a tangential relationship to such a matter to qualify under the TCPA's right of free speech. Rather, it applies so long as the movement statements are in connection with issues related to any of the matters of public concern listed in the statute. TCPA further defines exercise of the right to association to mean a communication between individuals who join together to collectively express, promote, pursue, or defend common interests. Multiple courts have determined that legal actions implicating the right of association within a group or organization meet the first step of the TCPA. Nobody is contesting that it falls under the TCPA. Anthony Siebert says that TCPA is full of poop. They can go F themselves, and they better hope that they have enough money to pay for the damage they have done. Maybe we need to make them more salty by hitting 300K. Well, I agree, but that's up to you guys. That's up to you guys. If the movement, quote, shows by a preponderance of the evidence that the legal action is based on, relates to, or is in response to the party's exercise of the right of free speech or the right of association, then the burden shifts to the non-movement to establish a prima facie case for each essential element of the claim in question through clear and specific evidence. In determining whether a legal action should be dismissed under this chapter, the court shall consider the pleadings and supporting and opposing affidavits stating the facts on which the liability or defense is based. Clear and specific evidence. I gotta pull this up. Just in case. Okay. Clear and specific evidence means more than the standards traditionally associated with notice pleading. That's not actually true at all. What's his citation for that? Lipsky. No, that's not a correct statement, and it's not a quote. Plaintiff must do more than provide fair notice of his claims. He must come forward with enough detail to show the factual basis for his claims. Yeah, he must provide evidence that is clear, and he must provide evidence that is specific to the claims. That doesn't mean, that's not more than the standards traditionally associated. It's not a higher standard of pleading. I guess they don't technically say that, but clear and specific is not an evidentiary standard. Clear and convincing is, but it's still preponderance of the evidence. Plaintiff must do more than provide fair notice of his claims. He must come forward. Yeah. Okay, factual basis of his claims, citing Lipsky again. Even if the non-movement can make such a showing, the court still must dismiss the action, quote, if the moving party establishes by a preponderance of the evidence each essential element of a valid defense to the non-movement's claim. That's 108. If the motion to dismiss is granted, the court must award the movement its court costs, reasonable attorney's fees, and other expenses incurred in defending the action as justice and equity may require, and sanctions against the party who brought the action as the court determines are sufficient to deter that party from bringing similar actions. They all think that they're automatically going to get all of their fees if they win. That's not true. As justice and equity may require, that's going to be fees related to the action. Waiting and conducting deposition that was not necessary to the TCPA, that might not be covered under that. And there would certainly be an argument that it's not. And that decision would probably be appealable as well. A party seeking dismissal under the TCPA may also seek findings regarding whether the legal action was brought to deter or prevent the moving party from exercising constitutional rights and is brought for an improper purpose, including to harass or cause unnecessary delay or increase the cost of litigation. That's interesting. They can seek those findings, but the only people who have caused unnecessary delay or increasing the cost of litigation are defendants. Plaintiffs have done nothing to increase the cost of litigation. Plaintiffs haven't engaged in frivolous motion practice. Plaintiffs have not set hearings and then canceled them. Defendants. Plaintiffs haven't done any of those things. Defendants have. Plaintiffs didn't request depositions prior to the TCPA being filed. Defendants did. Defendants could have filed this TCPA at any point prior to the depositions. That was their choice. The lawsuit is based on the moving defendant's exercise of their right to free speech. It is axiomatic that the petition implicates a matter of public concern. Twitter statements concerning plaintiff's improper behavior, exacerbated by his own public comments, sure. Coupled with turning his shock jock loose, I have not been turned loose by anybody except me, bad sir, to further fan the flames, perpetuated this controversy. All of the plaintiff's claims against the moving defendants are based on, relate to, or are in response to moving defendants' exercise of the right of free speech through their online communications. Interestingly, of course, they're ignoring that the plaintiff had the right to make the same speech. They're flatly stating that he shouldn't have said to his fans, please help me by countering the negativity. That's not his right to free speech or association, though. If you want to know why that TCPA going against TCPA might have some validity, maybe it's there. They're trying to suppress his right to answer. They've said over and over in this TCPA that he shouldn't have had the right to speak back. Moreover, the communications plaintiff seeks to silence concern his numerous improper interactions with young women and children at conventions attended by thousands of people. He's saying they're not true. implicating health or safety and the well-being of local, national, and international community of fans who attend these conventions. When asked about whether his credibility has been hurt by moving defendants' tweets, plaintiff candidly admits that there's a matter of public perception that I think we can all agree is pretty prevalent and powerful these days. And the allegations surrounding his alleged homophobia, anti-Semitism, and sexual harassment are being discussed publicly. Plaintiff admits he does not know whether he is suing for monetary damages, doesn't matter, and has not discussed any numbers of any kind of monetary anything. Doesn't matter. This lawsuit is to stop people from to end the public attacks and to somehow reach an agreement where these people do not contact events and production companies to try and keep me from working and making a living. Yep, that's fine. Nominal damages are a thing, but saying that the statements are defamatory is a victory. And you can actually seek that. You can seek a declaration from the court because that might be valuable to you, that what these people are saying is a lie. That's a remedy. That is the remedy of defamation. The money goes to repair the damage, but the remedy for the defamation itself is a statement that the court found it to be false and to grind the defendants into dust. That's very interesting. First of all, that's not a sentence at all. That's a weird statement. It's not a sentence, and he has never, ever expressed it. You're going to try and impute my words onto him. He's never said that. Never said anything even close. This lawsuit is based on the moving defendants' exercise of their right of association. TCPA mandates that the court dismiss a legal action against a moving party if the action is based on, relates to, or is in response to the party's exercise of the right of association. To be an exercise of the right of association, and these arguments are, largely unnecessary, but they have to be, they're necessary, they have to be made, but they're a foregone conclusion at this point. To be an exercise of the right of association, a communication must be between individuals who join together to collectively express, promote, pursue, or defend common interests. The moving defendants have the right to associate among themselves and communicate with others who have experienced plaintiff's abuse and inappropriate behavior, and to communicate about those common interests within the larger anime community. Plaintiff cannot show clear and specific evidence establishing each essential element of his claims against the moving defendants. Can he not now? After the movement shows by a preponderance of the evidence that the legal action is based on, relates to, or is in response to the party's exercise of the right of association, then the burden shifts to the non-movement to establish a prima facie case for each essential element of the claim in question through clear and specific evidence. Clear and specific evidence of each essential element of a claim is more than mere notice pleading. In order to carry his burden, plaintiff must provide enough detail to show the factual basis for his claim. Conclusory allegations do not pass muster under the TCPA. That's all quoting Lipsky. Plaintiff cannot show clear and specific evidence for his defamation claims against the moving defendants. To prevail on his claims for defamation against the moving defendants, plaintiff must prove that A, the moving defendants published a false statement of fact, the statement defamed the plaintiff, the moving defendants acted with actual malice, and the statement proximately caused damages. Because plaintiff is a public figure, that's, again, not ruled on by the court yet, and may not be ruled for the purposes of TCPA. They may not actually determine him to be a public figure for TCPA. We'll find out. He must show that moving defendants acted with actual malice. Plaintiff is a public figure given his pervasive fame or notoriety, such that he is a public figure for all purposes and in all contexts. Yeah, pervasive fame. You can't pronounce his name. Casey couldn't pronounce his name. The judge didn't know who he was. And by didn't know who he was, he thought that Ty was Vic. It's how famous he is. Everybody knows him. Except nobody. Alternatively, he is a limited purpose public figure with respect to the issue of his reputation in the anime industry by voluntarily injecting himself into the public debate about his misconduct in order to influence public perception among his fans, anime studios, and convention organizers. Actually, he didn't do that, but, Plaintiff publicly inserted himself into the dispute on at least 4 separate occasions. January 19th, where he encouraged his followers to do whatever they could to counter the lies. Broadcasting apologies on January 20th and February 13th, submitting a written statement for inclusion in the Gizmodo article. Again, they asked him for comment and he answered an article. Don't do it. Don't answer these vipers, they will never let you live it down. They will use your answers to bury you. And for endorsing the GoFundMe war chest on February 20th, 2019. Oh yeah, that was a huge injection into the public thing. This generated significant media coverage since the filing of his lawsuit, including a conspicuously timed feature in Variety released on the same day he filed the petition. Very funny. Very funny that you think that Ty Beard reached out to Variety, or that Vic reached out to Variety to publish that one. There you go. Do you have any evidence to support that conspicuously timed petition, conspicuously timed feature in Variety? Wow. Mignogna sues. They got... It's conspicuously timed. The title of the article is Vic Mignogna sues Funimation. They watched the news. They were following the news. You idiot. They were following the news. And when he filed, they printed the article. Clearly, plaintiff has more than a trivial or tangential role in the controversy. I mean, that's not actually a very strong argument at all. Has actively sought to influence the controversy through the media. So they cite WFAA-TV Inc. versus Macklemore. I don't think that's a great case cite for him. This dispute has even attracted the attention, oh, you disingenuous prick, of North Carolina attorney Greg Doucette, along with over 50 attorneys from around the United States. Name all the 50 attorneys and not law students that comment on updates in this case, analyze the legal issues, and respond to plaintiff supporters in a thread called the Thread Knot. Oh my God, can you get his cock out of your mouth? Gross. Gross. By the way, Greg Doucette was brought into this well after it was filed, well after the defamatory nature of it, and well after you would be making arguments about his public figure status, and he was brought into it by your clients, and you know it. Plaintiff cannot show with any certainty that any communication attributable to moving defendants caused him any specific harm. Oh, and you're using Greg Doucette to release stuff, Lemoyne. It's pretty obvious. Caused him any specific harm, especially as distinct from the numerous other sources of allegedly defamatory statements made in publications, lists online, or due to his being fired from Funimation and Rooster Teeth. In fact, plaintiff acknowledges that he is unable to provide clear and specific evidence that moving defendants' communications have defamed him or caused him to lose any work, describing his reputation as having suffered a death by 1,000 cuts. No, each one of those cuts is still damage. So yeah, they can... It doesn't matter if you have 1,000 people defaming you. All that matters is, can you provide clear and specific evidence of the people you're suing defaming you? Yes, of course he can. Plaintiff's reputation, such as it was, may in fact be dead, but he cannot show by clear and specific evidence that moving defendants' communications caused that death. Oh, I think they can. Court should dismiss the defamation claims. Plaintiff cannot show clear and specific evidence for his claims of tortious interference with contract against the moving defendants. This is a mistake. This is actually an interesting mistake here. They said that he can't provide clear and specific evidence that their defamation caused him the harm. They didn't argue that he couldn't provide clear and specific evidence that they defamed him. They're arguing on damages. That's a terrible mistake. Did they? Okay. Stick with me now. Plaintiff can now argue that it is uncontroverted that the moving defendant's communications have defamed him. It's right there. Right there. Well, I mean, they're saying unable to provide clear and specific evidence that moving defendant's communications have defamed him or caused him to lose any work. These are defamatory per se. They're arguing that first, I guess they're making a libel proof argument, which isn't going to work on Vic at all, especially because we can show constantly that he's still drawing business. But they're arguing that they can't provide clear and specific evidence that it cost him to lose any work. Calling someone a sexual predator or a pedophile or a child molester, that's per se defamation. That actually foregoes any arguments about damages, even in death by 1,000 cuts. They're per se defamatory. Now, maybe the damages are nominal, but the standard, actually, the actual law, the case law about per se damages is that if per se damages or if per se defamation occurs, per se damages, even if nominal, are mandated. Or not per se, the damages are mandated. The damages are presumed. So even if they're just nominal damages, this is a bad argument. They did not argue that he couldn't prove the falsity of the statements. They kind of argue that they don't defame him, but that defamation is per se. It's a matter of law. They may have made a big mistake here. If I were Ty, I would capitalize on the fact that they did not argue anywhere that he couldn't make a clear and specific showing that the moving defendant's communications were false. Because all he has to do now is just make a showing that they're false. If they're per se defamatory, damages are presumed. And then they just have to argue the fault, negligence or actual malice. They can easily argue both of those. That's a weird one. Weird mistake by Jay-Sean, I would say. Plaintiff cannot show clear and specific evidence for his claims of tortious interference with contract against the moving defendants. For his TI with contract claim to succeed, plaintiffs must show that an existing contract subject to interference exists. The alleged act of interference was willful and intentional. Willful and intentional acts proximately caused damage, and that actual damage or loss occurred. Plaintiff never had, prior to filing this lawsuit, any evidence the moving defendants caused him to lose any conventions. Oh, Kamehameha Khan? Court should dismiss plaintiff's tortious interference with contract claims. Notice how short that is? They don't even address the Kamehameha Khan text. They don't even address Ron specifically telling Kamehameha Khan all of that stuff, saying that they were going to talk to other conventions, saying that charges were coming. Monica's email to Chris Slatosh canceling after threatening to cancel over the phone. Plaintiff cannot show clear and specific evidence for his claims of tortious interference with prospective business relations against the moving defendants. For his claims of TI with prospective business relations to succeed, plaintiff must show there was a reasonable probability that the plaintiff would have entered into a business relationship with a third party. That's pretty simple. He gets invited to cons constantly. The defendant either acted with a conscious desire to prevent the relationship from occurring or knew the interference was certain or substantially certain to occur as a result of the conduct. I'm pretty sure there's statements from them saying it's good that he was fired. So there's that. The defendant's conduct was independently tortious or unlawful. Yeah, that would be the defamation. The interference proximately caused the plaintiff injury, and the plaintiff suffered actual damage or loss as a result. Pretty simple. He got canceled from a whole bunch of conventions, and it's pretty clear he would have been canceled, or that he would have otherwise been invited to even more. Like the tortious interference with contract claims, plaintiff never had a basis to bring these claims. Court should dismiss plaintiff's TI with prospective contract claims. Plaintiff cannot show clear and specific evidence for his claims of conspiracy against moving defendants. I mean, there's only plenty of evidence that Monica and Ron talked about that. This is the funniest one to me. Monica and Ron talked about the investigation. Ron's admitted it. Ron couldn't have knowledge otherwise. He said that Monica told him about it. He tweeted about it over and over, and he referenced it in his text to Kamehameha Khan. Monica and Ron have committed civil conspiracy. They are not a single unit. They are not married. They are fiancé. They are two separate entities. They are two separate defendants. They're not one. They probably never will be. And if they are, God help us all. They clearly committed civil conspiracy. Civil conspiracy is two people acting in a way to further an independent tort. That's it. That's it. Monica talking to Ron about the investigation. Actually, technically, Monica bringing the investigation is probably part of this. Lying in the investigation process or conspiring with Tammy Denbo as well is probably part of this. But either way, Ron is not Monica. Ron is not connected to Funimation. So even if they find that Monica is an employee of Funimation and therefore, or an agent, and Funimation has to indemnify Monica, that probably won't apply to Ron. Unless they can convince everybody that both Monica and Ron are agents of Funimation, then Funimation's on the hook. But we'll see. Emmanuel Natividad. Yeah, sure. Where's the contract, Nick? From Shane Holmberg. It's all over the place. Anyway, this one, civil conspiracy between Monica and Ron, a prima facie case of this is easy. Incorporating by reference and applying the facts and rationale associated with plaintiff's claims for defamation detailed herein, moving defendants respectfully submit that plaintiff's claim for civil conspiracy necessarily fails for the same reason. Moreover, if the moving defendants are actually employees of Funimation, the conspiracy claim is effectively self-defeating. Yeah. This is not actually well pled. They should have argued in the alternative. They should have brought up the enhanced standards for civil conspiracy that have to be specifically articulated beyond even, I think, what TCPA requires. They didn't do that. That was probably a mistake. So they cite Pledger here, and in Pledger, they tried to find conspiracy to occur without an underlying tort, and that doesn't work. So that's what that quote's about. Even if plaintiff could establish his claims by clear and specific evidence, plaintiff cannot overcome moving defendant's qualified privilege defense. Wait. Under the TCPA, even if the non-movement can make a showing of each essential element of his claims, the court still must dismiss the action if the moving party establishes by a preponderance of the evidence each essential element of a valid defense to the non-movement's claim. Oh, okay, here we go. The moving defendants are entitled to dismissal of the defamation claim and tortious interference with prospective business relations claim based on the defense of qualified privilege. Ms. Rial as the person assaulted and Mr. Toye as her fiance have an interest in the Funimation investigation, its result, and the right to defend themselves from attack online. There is no dispute that Ms. Rial believes she was assaulted by plaintiff or that she was aware of and participated in the Funimation investigation. Actually, there is a dispute on that. She's lying. So here we've got, what are they citing here? So footnote 143, qualified privilege. They cite Kane versus Hearst Corp. Qualified privileges against defamation exist at common law when a communication is made in good faith and the author, the recipient, or a third person, that's your first problem, good faith, and the author, the recipient, or a third person, or one of their family members has an interest that is sufficiently affected by the communication. See Holloway versus Texas. A communication may also be conditionally privileged if it affects an important public interest. Citing Hansen versus Our Redeemer Lutheran Church, the church neither entertained serious doubts as to the truth of the statements nor made these statements with a high degree of awareness of their probable falsity. The communications appeared accurate. The church reasonably believed Schiffer, and church members and parents who received information had an interest in the funds and information about the funds. So they're going to argue that their investigation was protected by qualified privilege, and therefore their right to talk about the investigation and to further lie about Vic is protected by qualified privilege. The problem with this is we have no evidence that she raised the story in the investigation, and if she did, it's not brought up, bringing Funimation into a civil conspiracy claim for failure to adequately investigating and then lying about it. I don't think they've got qualified privilege here. There's no dispute. And again, there is a dispute that she believes she was assaulted. Absolutely. She's lying about it. It's pretty clear. Funimation, after conducting the investigation, talking with multiple witnesses and plaintiff, chose to terminate him. Mr. Toye was aware of, why is he Mr. now? Was aware of multiple allegations from victims concerning plaintiff's predatory actions, including his fiancée, Miss Rial. Further, the contemporaneous articles written about the plaintiff, along with numerous statements by individuals online, support Mr. Toye's belief that plaintiff was a predator. Not only is what they said the truth, because Miss Rial and Mr. Toye reasonably believed it, even if they were mistaken, they are not liable to plaintiff based on the qualified privilege. That is not, no. That's a funny one, but there you go. And then finally, plaintiff is liable proof. Again, a throwaway argument here. Plaintiff is liable proof. Finally, setting aside the massive causation problem that plaintiff has, showing any statements by moving defendants caused him injury, won't have to because they're defamatory per se. He is liable proof. Plaintiff is liable proof not only because of the defamatory articles. This is not, the standard of liable proof is so far ahead. But based on his own admissions, those defamatory articles are still within the statute of limitation. So if you're admitting that they're defamatory, then he's not liable proof. Because they have, you're saying that they have caused him damage. This is self-defeating. Again, if the plaintiff is liable proof because of defamation, then he's not liable proof because the defamation occurred. But based on his own admissions, i.e. persistent rumors of pedophilia, that's undoubtedly advanced by his public behavior with young girls. That's, again, no. Have followed him for years and have routinely been ignored by everyone for years. Under such circumstances, he is liable proof and therefore cannot establish damages. So Waid versus Schiffers. Let's read their citation here. Although the three statements Waid complains about may be false, the earlier newspaper articles and the disciplinary orders describe conduct that would have ruined Waid's reputation prior to the publication of Schiffer's article. For example, one disciplinary order established that Waid had failed to complete abortions performed on several patients and that he had failed to repair lacerations which occurred during abortion procedures. As a result of this conduct, the Texas Board of Medical Examiners placed Waid on probation for 5 years. Another order established that Waid continued to function as a physician despite having been placed on probation by operating 2 methadone clinics. These actions and others were reported in the numerous newspaper articles that were included in the defendant's summary judgment evidence. While we need not include all of the details of these articles, let it suffice to say that Waid has been the target of extensive negative media attention for at least 10 years, so much so that it is impossible to believe Waid's reputation could have been further damaged by the statement in Schiffer's article. Without injury, the trial court's order granting the defendant's motion for summary judgment was proper. As a result, we overrule this issue. Of course they can't show this because Vic has not been dogged by these things to the point of being canceled from conventions or losing work for 10 years. It all happened starting in January and February. That's it. All of the damage occurred now. So you can't say that he couldn't be damaged because the damage didn't occur prior to January or February. So this is a throwaway argument. Conclusions and prayer. For these reasons, the moving defendants respectfully request the court grant dismissal of all plaintiff's claims, award of reasonable attorney's fees and costs in accordance with TCPA, a hearing in which plaintiff is present for cross-examination for determination of an appropriate sanction, and such other and further relief to which moving defendants may be justly entitled. J. Sean Lemoyne. Now, I'm not going to go through all the exhibits. I'm not going to go through all the exhibits tonight because it's already 2 a.m. I have an early morning. I will think about going through the exhibits in a future show. Many of you have read them. I encourage you to go and look through them and determine for yourself what those exhibits say, what they mean. Understand that there's going to be a lot of discussion about these exhibits going forward because many of them are going to be, at least I would suspect, based on what he said, there will be motions to strike a lot of these exhibits, these affidavits. This stuff is pretty salacious. It's not necessarily probative of the claims, and it is extremely prejudicial, and therefore may not be admissible. Also, a lot of it is hearsay. Emmett Plant is making statements on behalf of someone else. So is Emmett Plant's girlfriend making statements on behalf of someone else. Lynn Hunt is making statements on behalf of other people that are not apparently available. I haven't read all of the affidavits yet. Because some of them were only produced in this. So they haven't been produced in Discovery. So it's hard to say. I don't know when they got them. Like I said, I haven't had a chance to look at those specific affidavits. But there will probably be motions to strike every single piece of evidence, whether they win it or not, unless it's like the deposition. They're not going to try and strike Vic's deposition, obviously. But striking articles that are prejudicial and are based on hearsay, that's going to be that'll be a part of it, I would guess. Striking any of these affidavits would be part of that. So we'll be talking about this evidence going forward. And I assume that's going to happen very quickly, because if I would wager that Lemoyne is going to try and set this hearing as fast as possible because of how much stuff is in it. So we'll see how that goes. All right, guys, what I'm going to do now is I am going to go through the super chats. I'm going to pull the GoFundMe up one more time. We're going to go through the super chats. We're at $230,926. Thank you. Polaris for you, Kenneth Lever, Mary Dalziel, Anonymous, Andrew Stout, Anthony Siebert, Anonymous, and then we're back to Brian Farrer. So thank you guys for donating. I'm going to go through the super chats and the justice chats, and then we'll close out the show for the night. I most likely will not have a show tomorrow. I will be traveling. I don't think I'll have a place to, I'm traveling now, but I have a place to broadcast. I don't think I will come tomorrow, and maybe not Sunday either, and maybe not Monday. I will try and keep updated, but Tuesday should be a broadcast day. I'm going to try and do something one of these days over the weekend, if not Monday as well, because there's just so much to talk about. But if you leave during the super chats, thanks for hanging around for now, and we will continue to look at this as it develops, and we'll see what happens. Very, very interesting. Very, very interesting. Jamie's TCPA, I don't have it yet. I heard it was filed. That's one of the reasons I want to be able to do a show over the weekend. We'll see. I might be able to get a show in tomorrow. I might. I don't know. It depends on a lot of factors, okay? So if I can, I will. Otherwise, we'll see. Could they get in trouble for egregiously taking advantage of the privilege of the filings? Look, all of the crap that they put in the filings has to be responded to, and anything frivolous runs the risk of increasing costs, and those costs could actually be assessed against them. They can. The TCPA allows costs to go to the plaintiff if the court finds the motion fileless or frivolous or causing undue delay or something like that. They waited a long time to file it. They had extensions due to their actions that were unnecessary to make the filing, hopefully to their detriment too. So anyway, let's start with these justice chats. Justice chats first. Here we go. Where are we? Oh my goodness. We are here. Michael Rule. So these were way before the show. Michael Rule says, what happened to my $20 justice chat? I read it at the beginning of the show because I missed it yesterday because Streamlabs kicked it off. And they kicked these off too. So about 7 hours before the previous stream, since I live in the Netherlands, it's hard to watch live. Got it now, and I will look for them in the future. So I'm very sorry for that. I have to check the way Streamlabs works. I have to check an extra place. So very annoying. Michael Rule says, also, if you prefer people using the justice chat, I suggest you don't ignore them. I didn't ignore it. It's the way Streamlabs refreshes and cuts off stuff after a certain time period. And I can't change that. There's not a setting for me to adjust. So I do apologize. Knight of Hopex says, the crap people assume TCPA will get them out of a lawsuit. Jokes on them, probably won't. Good luck, idiots. Tainted Coochwater says, I know your undisclosed location. Of course, being a pro grifter, you took the money and ran. To where, you may ask? Kokomo. You get there faster and now you're taking it slow. That's where you'd want to go, way down in Kokomo. No, I'm still in Minnesota. Tony says, check out my channel for the new At Ron Toye's Deposition remix in honor of Kick Vic and Vic Kicks Back. The deposition was the highest purity of cringe to ever exist. Also, check out Ear Juice's new remix, Sheepdog, on his channel for the most Tony lit of beats, or no, the most lit of beats. There you go. Thank you, Tony. Ear Juice U says it's musical helper for Ron remix. By the way, he put Tony whoops. By the way, us parody channels need to shill now. I have 18K subs and lucky to hit 200 views now. Other channels flagged or deleted for very little and a total loss of views. Support parody before it's gone, yo. Yeah, guys, support parody. I agree. That guy thing whatever says comics are dead. My local game store owner only orders +1 on his pre-orders and barely breaks even on comic sales. 60% of his profits come from TCG's tabletop releases, 25% from accessories, and 15% from promo events. Comics Corner is dead weight. Short Round says it's my birthday today. Hey, happy birthday, Short Round. So giving Nick $350 to say, God damn it, Loch Ness Monster, I ain't gonna give you no tree fitty. Bad Police Advice 10 says, if you don't sign the ticket, legally we can't prove you got it and no warrant can be issued. Hashtag F the police, coming straight from the underground. Pretzelman718 says, Kick Vic sends envy. Monica, obvious reasons. Greed, Lemoyne, GoFundMe. Wrath, Jamie Markey, won his balls and head. Gluttony, Shane for shoe eating. Sloth, Casey for producing Discovery. Lust, Toye crushing on Vic. And Pride, Doucette, super lawyer. Snack Sheet says, according to this punch card, if Vic loses the case one more time, I get a free oil change. ENTEC4 says, Racket's affidavit when? Why would I file an affidavit? Why would I file an affidavit? Why would I take advantage of the privilege proceedings to talk about things that I've discovered in my journalistic investigations that maybe were omitted by the defendants in their motion, or things that may have been overtly misrepresented? Maybe I don't know why I would want to draft an affidavit about any of that. Schwazoom says, these are the people who are not letting evil triumph. Is this really a lawyer? Presumably. I've seen less overdramatic and garbage writing from 12-year-olds on Wattpad. What kind of judge? Secondly, Vic was never asked about Blankenship's story and deposition. Important? Why do you think they did that? Because he would have said no. No. Short Round says, well, since we're going hard in the paint on Jay Sean, I wonder if the Bulls have taken over since he has 45% lung capacity and can't please his wife. I heard he warmed up the Bull and his anus looked like an inside-out windsock. Hashtag don't talk to the police. That's pretty graphic, Short Round. Schwazoom says, I've seen Vic touch girls on the arms and shoulder, put their hand on the wall near their head, and whisper in their ear. Therefore, I believe he's sexually assaulted women all over the U.S. This is a real affidavit, folks. Deep Fried Lettuce says, hey, Nick, just bought a wallet with your code. Also, I do not recall uploading your promo code to Honey, so more people will use it. Oh, well, thanks for not doing that. Sigma Zero says, is it possible for a filing to be so blatantly defamatory that it can become a cause of action against the attorneys that filed it? Also, Jack Daniels is best bourbon. Peace. No, it isn't. Not even bourbon. Filings are basically privileged. The remedy would be very, very different for that. Okay, where are we? Okay. Monica's farts after Chipotle says, Moronica paid thousands of dollars to their lawyers to watch Nick's show. With priorities like those, it's stunning the Fuhrer hasn't already won the case. Short 1830 says, woke up for work, so I'm catching the tail end of the stream. I don't know the context to anything, so lemois. If the judge should not watch my videos because it would probably be prejudicial to the defendants if he did. So I don't think he would end up watching my videos, but I don't know. He's welcome to. Hey, what's up, Chup? Schwazoom says, I get that this is the opposition to Vic, but they need to convince a judge and or jury. Do they really think that they can just portray Vic as this evil caricature and have it fly? Especially with video depositions showing his demeanor versus Veronica. They apparently do. Schwazoom says they argued that Vic has a history of pedophilia in the TCPA and then argued that no defamation can be proven. I know what's said in the TCPA is privilege, but it seems highly self-defeating nonetheless. Of course. They have several self-defeating arguments. Schwazoom says, at the very least, I think you should go through the affidavits. Not tonight. Not tonight. I'm sorry. I cannot. That'd be another hour, and I can't do it. Kevin9793 says, that whole document sounds like it was cut and paste directly from Twitter. It's sickening. Schwazoom says, meant to ask what kind of jury or judge would be swayed by that ridiculous over-the-top dramatics, like calling him evil and that entire hysterical thing. Some would. Some would. Some, not all. So I don't think Chup will. All right, on to Super Chats. The Arglist says, think timestamps are getting flagged on your vids. They might be. They're hard to find, too, because there's so many comments. I try to find them. I pinned a couple today, but I'm looking for them. Inquisitor Jack says, donated 20 to the GoFundMe, not as Jamie Yander Hamster Markey. Toasting the show with some Old Scout American whiskey, first time watching live. Hey, welcome to it. Mortzula, your artist quit. No, my artist did not quit. Just this week has been very, very personally busy for me. And it's been hard for me to get him topics in time for thumbnail. He gave me a bunch of thumbnails for the other streams, and I'm going to change them. But I just haven't really been... I've been really tight on time. Gawker's Death Rattle says TCPA more like T-crap, or TCPAP, TCPAP. Wheeze. Earjuice says Musical Helper has a new dubstep Ron Soye deposition song. Check it out at Musical Helper channel. Yo! I'm a sheepdog bro, so look out for my flock. Hey, thanks, buddy. Mario Carter 13 says, Mr. Sabbat, you've been cast as Ayame in Fruits Basket. How did you get into character as a snake that seeks warmth in the blouse of an underage girl? Friggin' Harlock says, that light in the background is screwing with your autofocus. Oh, did I not turn off the... Did autofocus get turned on? I'm sorry. Ethan King says, in for another funny late night stream. Clever Fox Soul says, just wanted to help give support if you don't mind. Could I ask what a TCPA is? It's the Texas Citizens Participation Act. It is an anti-SLAPP statute. And basically it says if you're filing a lawsuit just to stop someone's free speech and the lawsuit is without merit, then the lawsuit can be dismissed on those grounds. So Reek says, for the Skittles Fund, thanks for the snacks. Thank you. The Murloc Horde says, if you were ever in Van BC, I will buy you a shot. So British Columbia. We'll see. I've been to Canada once. It was pretty. I'm with it. BJ Sparn says, is it harder to get a TCPA or a CPAP? Apparently a CPAP. Toast Bill Clinton. Because you got to crowdfund a CPAP, but you just got to promise to pay Lemoyne on the TCPA. Toast Bill Clinton, thanks for the donation. Dex Terminax says, Hey there, Nick. I got some Glenlivet 12 for my first scotch, and I'm raising a glass to you for all you and Ty have done for Vic. Cheers, good sir. Hey, cheers back to you. Thank you so much. The Gun Kid says, sorry, Nick, I have to withdraw my statement. It was a case of mistaken identity since all weebs look alike. Oh, okay. Thank you. Oh, that was on the underage girls in the hotel incident is in a video. Okay, never mind. Thanks for clarifying. Sorry, it was the end of the video. Chicken Speed says, will Funimation fire everyone involved in Vic's lawsuit, and will Monica have to change professions? I think that's a likely outcome. I do think it's a likely outcome. 2012 Jameson says, Baylor versus Passmore would help Waid. I can email you. Would help Waid? Why would I want to help Waid? Alpha Squash Primo. Thank you for the donation. 2012 Jameson says, Baylor versus Passmore defeats TDMA requirement. Oh, so help your boy Zach against Waid. Yeah, email me that. If you're still there, 2012 Jameson. Also, I'll just try and find it. Baylor versus Passmore. Very interesting. Scabbles said, Sebastian Soul donated all his PB&J money. Scotty J says, hey, Nick, I hate to shill on your stream for this, but I know lady and her family need help due to a husband's lost job. Where can I send the GoFundMe link? I had to turn off links. I had to turn off links in my chat because we were getting hit by the Chinese porn spam. So I don't know where to send the GoFundMe link. Jeg says, I wonder if you can get Rand Paul on for your Second Amendment stream. I doubt it. Alex Keller says, just want to give a tip to a fantastic individual who doesn't bend, but breaks the vile humans that would destroy an innocent man with his wits. Much respect, Nick. My pleasure. Thank you. Ranstein Hernandez says, hey, Nick, just wanted to say it's been a great month. Got my driver's license. Congrats, buddy. My mom's now a permanent U.S. citizen. Congrats, buddy. And I got hired to a new job. Triple congrats, man. That's awesome. Awesome month. Chuck Mung says, does the Ridge wallet have a compartment for my Viagra? Yes. Although the Viagra will get squished. Malachi Tomlinson says, drinking a 103 proof Old Smokies moonshine. Cheers. Oh, wait. Cheers. Cheers back to you. Alpha Squash Prime Zero says, donated $10 earlier and adding another 5. Fridays at my base are usually long chill days, so I listened to the depositions you uploaded. Thank you. Hey, my pleasure. My pleasure. S.E. Tonks says, really killed that ad read, Nick. Just killed it. You know, I got to do it my way, right? Like Frank Sinatra or whatever. Malfunction. Thanks for the donation. Gamer Hero says, oh, they set the tone all right, and it's disgusting. Hugh Gak says, Your Honor, which sounds more alarming. Kiwi farms are pretty ugly little liars. But all jokes aside, KV 15 Gorillion, I stand with Vic 0. Jedi Nightwing says, Nick, Monica, and Ron are grabbing your attention with that first page by starting off with a joke. I know they're doing that. I know what they're doing. I don't think it's a good strategy with Judge Chupp. That's the difference. No one important says, oh God, this TCPA is full on clown show. Lurkmore 101 says, let's be honest, J Dolph just really likes looking at pictures of Vic kissing things. Deep down, he wishes that Jay was him. Harbinger 344. Oh, Jay, the, whatever. The girl in the picture. Harbinger 345 says, so famous, I had no idea who he was until recently. Yeah, you're going to find a lot of that. All Out of Bubblegum says, we are Legion. Werex says, what is this, a Polygon and Kotaku hit piece? James Ridge says, Low T Greg is still going on about the GoFundMe. If he is so sure that it's going to the defendants, he should put his money where his mouth is and donate $500 to $1,000 to the GoFundMe. He'd have to crowdfund that donation. He can't afford it. Werex says, I take that back. Polygon and Kotaku isn't this bad. Humble Marty says, WTF, is this a court document or a freaking fanfic? Leaning towards the latter. Indie Visualist says, Vic is a Christian, not a saint. If Monica paid attention to those Baptists or Catholics, she would know all good Christians admit to being sinners. Yeah. I don't know any Christians who admit to being perfect. Ethan King says, I feel like I'm hearing a bad fanfic. CC Ria says, since this is obviously another defamation attempt, could Ty present this filing to a jury as evidence of a continued witch hunt? It'd be better to just strike it as prejudicial. He won't be able to strike the filing. I mean, he'll be able to strike parts of it. Not all of it. They'll just defeat it and just move on. Mr. DJ Fly High says, maybe Jay is trying to use the shock value. Well, it's like Jay Sean is a shock jock. Grievous Error says, security guards are usually half artard as it is. Timothy Reaper says, did you notice what was said in footnote 19? Let me go back to that. For reasons unknown, members of the Reasonable Rangers refer to him as the Führer, including his mother. See Vic Mignogna. Yeah, I guess they'll have to explain in the filing that they're trying to... That again, this is prejudicial arguments. It's a prejudicial statement because he's referred to the Führer in response to Full Metal Alchemist. Aegis Thomas says, Nick, as a fake internet lawyer, what would you say hypothetically be best possible charges in a lawsuit against Rooster Teeth? Details, please. I stand with Vic. Best possible would be to impute the words of their employees and contractors onto them, because Rooster Teeth was very quiet in this, or to wrap them up in the civil conspiracy. If you could say, prove some communications between Monica Rial or some of the other defendants and Rooster Teeth, or if you were to bring in Sabat, for example, and prove that he had ties with Rooster Teeth and influence over at Rooster Teeth, that would be over Vic. You know, at this point, I'm not sure that evidence exists, but it might be out there. Pirate Skeleton says, is their defense a weird combo of we didn't cause damage and he had it coming? Might as well throw it all against the wall. R.A. says, as I've learned from this in Kavanaugh is that all I've learned from this in Kavanaugh is that my life could be nuked any day by any of the chicks who were around me in college. I had a psycho sorority chick stalker, and Vic's words about being in shock as his life was destroyed were too real. F for us Zoomers in the world we're inheriting. They don't even have to have been around you. They could have gone to the same college as you. They could have worked in the same town as you, for all you know. All you have to do is have a big enough name. And then suddenly, I wonder if Kavanaugh is going to play into any of this. That'd be interesting. Grievous Error says, at best for Kick Vic, Rial is trying to cover an affair. Ooh. No One Important says, hey, Nick, can I get a how embarrassing mug? You reading this makes me want to take a sip out of it each time something stupid comes up. Why don't I have one of those? Rev Brother Jack Music says he leaned the wall. That's called Cabedon. They're accusing him of a Chad move that is literally an anime trope. Lols. Damien27 says, heck, Nick, first ever super chat. Thank you. Great work. Not related to law, but who's your favorite Minnesota Twin of all time? My vote goes to Kirby Puckett. I'm going to go with Kent Herbeck only because he has not enough vowels in his name. Kent Herbeck. I'm not a big baseball fan, but, you know, Kirby, of course. I think Kirby's got to win, right? Mark C says, Nick, I'm tweeting you a Baron Silas Greenback video from Danger Mouse. You tell me who he sounds like. I'm guessing Lemoyne. Underscore says, I hope tie TCPAs so Ron can double TCPA. Leon Lynn says, weird they did this over email and not phone. Did a lot over email. They didn't turn over all those emails, though. Rocky Top Otaku says, Red Bull and Russian Standard. Mistakes were made. Yuck. Jack Riley says, I'm perplexed by the fact that there's still the false whatever means possible narrative. Also, first super chat and newcomer to the channel. Hey, thanks. Welcome. Whatever means possible narrative. Yeah. I'm not exactly sure what you mean by this. I guess you just mean, what do you mean by this? I mean, there's the by any means necessary. Is that what you're talking about? The by any means necessary, like, book? Are people still talking about that? Felipe M says, well, this is the material Vic needed against Funimation, isn't it? What a load of crap without evidence. And Ty says this guy is a class lawyer. I don't know if Ty said that, but Ty's going to be polite to his opposing counsel. Esme Illis Anime says, Nick, you had a kinky stream. I needed a blow dryer. Hide the candy from Monica. Daddy LP says, check your Twitter replies. Over 9K hours in MS Paint. Ooh, I'll have to check it. Shifting Sand says, do multiple previous unproven claims of inappropriate conduct really boost current unproven claims of inappropriate conduct in a TCPA? That's what it seems they're going for. And again, the argument is problematic because no damage occurred prior to this stuff happening this year. He was still going to conventions. He was still recording. The defendants still liked him. All still liked him. They still acted like his best friends. Up until January. That's when the damage was done. So no, all of that pre-existing stuff. Oh, that pre-damaged him. Did it? Did it? Monica was hugging him in December on video. Because he so viciously assaulted her and she's so traumatized by it that she hugged him, probably kissed him on the cheek, hung out with him, flirted with him. Oh yeah, flirted with him and all that while married to Ron. That's interesting. For 12 years after the alleged assault. Because she forgave him. No trauma there. Silver Dragonian, thanks for donation. Jason of the Great Awakening says, Nick, I have a potentially revealing announcement. You are a shock jock. I don't even know how you define shock jock. I don't think so. Indie Visualist says, ANN 13019 article starts far from perfect. Ampathos guy says, Nick, could you ask your artist/short round, don't remember which, if I could use the Fear the Beard patch logo for a non-profit coin project? You'd have to ask short round on that one. K Maxor says, sure, since Monica wants to use this suit to further slag Vic and Lemoyne is obliging them, could that put Lemoyne on the hook for the defamation as well after? No. Chris Jablonski says, Nick Rekieta, the architect of the GoFundMe war chest, the shock jock of YouTube, the mastermind behind grifting, the best law journalist the world over. I'm going to have more names than Constantine Valdor by the end of this thing. Indie Visualist says, ANN did not blur photo of 8-year-old boy Vic hugs. Finfrog says, for Lemoyne's bishy soy jerk attitude, shock their jocks with capitalism. Winged Paragon says, thought Broly being canon would mean Vic would be around Funimation more often. Since he wouldn't be recast, they found another way to get rid of him. Maybe. Maybe. Brian W. says, Jadolph Lemoyne's intentional misrepresentation of you and of Vic with vicious misquoting, perjury, and unethical prose makes me murderous, grrr, in Minecraft. Maddie P. on the road says, F bicycles, please press F for the car lanes we lost. Yes. Yes. Put them on the sidewalk. That's what sidewalks are for. Michael S. says, sorry coming in late. What is this document? Keep up the good fight. Have some shekels. Tip your bartender, folks. This is the TCPA motion filed by Monica and Ron Toye. Individualist says A&N admits the photo blurred original in the update. Conspiratorial Walnut says make crucifixion an acceptable punishment again. Austin Heartless says when Lemoyne tries to depose you, pull a Chad move and depose him instead. Crotch says hopefully Jadolph Lemoyne has to go get down on all fours in court and eat his ridiculous TCPA document out of a dog bowl like the little B word he is. Ooh, goodness. Ayla123 Hamora says, hey, Nick, you should give Viking Blood a try. Also, ever watch Fact Fiend with Carl Smallwood? Nope. I can totally both of you sitting back with drinks. Keep fighting the good fight. I think you totally see sitting back with drinks. Keep fighting the good fight. Love your streams. Hey, thank you, Ayla. I'll have to check it out. Jenny Talia and Aaron Sutton, thank you for the donation. Zombie Man 980 says, so there's a new victim of the VA of Vidal. Esme Illis Anime says, Greg, you female cleaning product. Stop being a female cleaning product. Oh, hey, Nick. Ricky1186. Where do we go here? Ricky1186 says, how disgusting and misleading and just badly filed, and they paid for this. Veronica, I would start shouting malpractice by your own counsel. Might be your only option at this point. Night Shadow, it's going to be real funny if they lose this, can't pay their counsel, and their counsel gets sued for malpractice. Oh, God, that would be funny. Or ethics violations. Night Shadow 998 says, now that it is official, could you consider covering this the class action lawsuit against Nintendo for Joy-Con drift? Sure. Sure, I haven't seen anything about it. I've been so focused on this one. Claire Ember says, oh my God, liars, liars, morons on fire. Someone take Ron's crayons away from him and stop him from writing this horrific fan fiction, because surely a real lawyer wouldn't have written this absolute and total crap. Jason of the Great Awakening says, my hope is that 1% of the 2.2 million victory, my estimate, goes to burning a giant effigy of Sean's chair. I think you mean Shane's chair or Sean's chair, while anime fans dance beneath. Ryan Cole says, how confident should Ty and Vic be now after reading this? Also, I'm pretty sure Monica will marry Ron. I think Ty was confident before this was filed. After filing, I doubt this messes with his confidence because they don't prove any affirmative defenses at all. Actually, they don't even really have an affirmative defense section in their motion. So, I mean, they'll have a response, presumably, and I guess get to offer preponderance of the evidence, but they don't assert their affirmative defenses in their motion. So all Ty has to do right now is make a prima facie case. Also, I'm pretty sure Monica will marry Ron for legal reasons and consummate her marriage by pegging our favorite Alzheimer's soy boy. The legal reasons, if you mean marital privilege, it will not help them in this cause of action. It's too late. Al Valentin says, poor Judge Chupp will be reading this pile. My God. Well, his clerk will. Samantha Schoner, thank you for the donations. Keldeo the Horse says, I think my girlfriend broke up with me and we've been together for over a year and a half. Can't confirm, but it feels terrible. This is my first relationship. F. Thanks for keeping me entertained, Rackets. Hey, buddy. There will be another girlfriend. So, chin up. Chin up. Or it might be the same one. You never know. Aaron Sutton says, since Vic is suing multiple parties, will there be multiple trials? No. First they have to sort out, I mean, they'll have to schedule trial, and it will be, because for efficiency, all of the parties would have to be at the trial because, you know, all of the lawyers might have to examine or cross-examine witnesses. So the trial will be a mess, but no, there should be one trial, and we may see some defendants removed. They could win a motion on TCPA. They could settle. Lots of things could still happen. Could you see Vic winning against Monica and Ron and settling with Funimation? Absolutely. Mike Lombardo says, could someone tweet me the link to the TCPA? My handle name is the same as on here. Thank you. Anthony Siebert says, EDF Fencer Squad here to bring the heavy weapons to take out the alien menace. EDF, EDF. Bad Vibe says, is there a rule against presumption of a ruling in a filing, i.e. public figure? No. You make the argument, but you presume the outcome. That's confident. Or that's just persuasive writing. I shouldn't. Yokosai says, thanks for all you do, Nick. Hey, you're welcome. My pleasure. Leon Lyon says, thank you for reigniting my passion for law, heart. My pleasure. Hammer Bro says, Nick, have you seen the entry for Spicer, Minnesota in Wikipedia? Apparently you were listed on the right side panel for government. No, that can't be right. I'm looking. I'm dead. Let me draw your attention. To down here. Government super lawyer Nick Rekieta. Oh my goodness. Thank you for pointing that out. Oh my gosh. Okay. Asia Fraser says, Rekieta is racist every night he's in red face. That's just how it goes. DJ Grimmick says, I'd love to share with you a funny Kick Vic encounter I had with a I was there screecher who sent me a Tumblr post as evidence on February 12th. Well, email it to me if you got it. Email it. Blaine20 says, are we the intended target of Vic's proxies? I guess. Blaine20, objection. I am not half retarded. Defamation. Jason of the Great Awakening says, could there be copyright claim on Monica stealing Vic's hair? Randstein Hernandez says, message to the chat. If you guys like rock music and looking for new songs, check out Bloodywood. Those Indians know how to rock. Highly recommend. Mike Lombardo says, correction. At Ruthless Otaku is my handle. Lol. Super Range 128 says, did you see the lo-fi hip-hop parody based on Ron's deposition? YouTube watch URL is UVYR capital Q YK capital E A78. Also, objection to form. I did not. And I'm not going to watch things on stream because apparently showing the parody song for Ron Toya's deposition has been copyright claimed. On Rial's deposition video. So that's lovely. Someone who didn't have any rights to that song because they didn't make it because it was a parody song, which is under fair use, and I had permission from the parody creator, has claimed the money from it. So that's nice. Not the super chats, just the ad revenue. Blaine20 says, all of the sexual harassment but not rape allegations must prove the existence of a female incel culture. If we're to believe these feminists bagging on men who can't get women. Freighter J says, what changed in January to start this? Well, Broly was released. That's what really kicked it off. Blaine20 says, as yet, nobody has brought up that Vic and the VAs may have discussed the rumors, aired out concerns, etc. Either they ignored it entirely or the VAs assured Vic they didn't buy them. Well, I think it's that second one. Blaine20 says, shout out to Miss Meadowkitty. Zero Sa, thank you for the donation. Blaine20 says, shout out to Gothic Sushi. She will be a guest at Bubba Fest. I look forward to seeing you. Me too. Leon Lyon says, donating again so Nick will say, Monica Rial is the scum of the earth on stream. I hope she has to work retail after the conclusion of this case. Aaron Sutton, thanks for the donation. Zero Sa, a ruling, lol. And Eraser Rain Lantier says, if they beat one of the TCPAs, will it affect the others in Vic's favor? Would they consider the verdict on the next one? No, they're supposed to be looked at individually. So, all right, guys, let me pull up Whiskey Drinking Lawyer. We're going to play the outro music here in just a moment. I get it set up. And So this is the end of the show as the outro music is now starting. So, where it is? Oh my goodness. Bad Vibe says, will Duchette now be a fact witness with the TCPA filing? No. But isn't it interesting that he got included in there for no point? There's no purpose for it. There is literally no purpose to include that other lawyers are commenting on this case. That doesn't prove anything about any of the claims being made. They're trying to use that to, I guess, make a public figure argument, but they are so late to the game that there's no way that the public figure status could be related to the claims. That's the problem here. It's relating to the claims being made. Anyway. So here we go, guys. That's what I got for you tonight. Again, I'll be traveling over this weekend. I will announce on Twitter if there will be a stream either tomorrow or Sunday or Monday. All 3 of those days are very up in the air, but there is a lot to talk about. So I will let you know. Thanks for tuning in tonight, and I will see you very, very soon. Have a good night. Peace. There's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea. Post on Twitter as we hear lawsplaining tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law